Okay, we are live.
Thank you. Good morning, folks. My name is Joe Rafferty. I am a senator here in Senate District 34 and chair of the Labor and Housing Committee. Want to welcome you this morning and appreciate you joining us for today's hearing. This morning, we're going to hear four LDs, LD 137, LD 248, 305, and 358. Please keep in mind that the committee is assembled and we are going electronically today, as we have been doing, for the purpose of inviting public comment on the legislation. But I need to run through a couple of things, first of all. It is being live streamed as well simultaneously on YouTube. So that means anyone who is a participant in the meeting via the Zoom section, you can be seen and also heard if your microphone is unmuted. People on the Zoom meeting waiting to testify, you won't be seen or heard until you are called upon to speak. The meeting will be recorded and available to view on the committee's YouTube channel soon after this meeting has concluded. In a moment, I'll introduce the committee, but please keep in mind during that there's a slight transition period from when you are being called upon to testify, and there's a little bit of a delay in electronically before you'll actually appear physically in front of us and also live. So just be patient, and if you would remember, please, to in the corner of your photo, just make sure that your name appears and when you do testify and where you are from. This format, although it's still in a new phase to us. I mean, we work out kinks and we have different situations that arise typically in every meeting, but just be patient. We'll work through it. And if there's help we can offer you, we'll do so. We have a clerk working with us, and there is IT folks available should the need arise. Members are reminded, participants are reminded of the chat link, excuse me, the chat ability. You can use that, but it's not to be used for discussion. I mean, we can use our caucuses to do that. But if you need to get a message directly to me or one another, it is helpful. If you have any questions as we listen to folks that are going to testify, please direct your questions through me, or at some point this morning, actually Representative Sylvester will be standing in for me as chair. And we'll go from there. Okay. At this time, I'd like to allow folks to introduce themselves. The first I'll call on, please, is Representative Sylvester.
Thank you, Senator. My name is Mike Sylvester. I am the representative from District 39, which is the Eastern Peninsula portion of Portland and the Fighting Islands of Casco Bay, and also the birthplace of the Italian when Mrs. Amato sent her husband with a sandwich that he could wrap and put into the pocket of his coat. And I'm also House Chair of this committee.
Thank you, sir. Senator Guerin is testifying at another committee right now. With us is Senator Miramont.
Good morning, Mr. Chair, and everyone joining us today. It's a pleasure to be here. I represent Senate District 12. Dave Miramont's my name, and that's county seat of Senate District 12 is Rockland.
Thank you. Representative Bradstreet.
Good morning. I'm Representative Dick Bradstreet. I represent House District 80, Vassalboro, Windsor, Somerville, and part of Augusta, and I have been a fan of Amato since before Representative Sylvester was born.
And still eating the original, right? Representative Drinkwater.
Good morning, Representative Gary Drinkwater, District 121.
Thank you. Representative Gear.
Thank you, Mr. Chair. I'm Tracy Gear, representing House District 9, which is Kennebunkport and the coastal parts of Biddeford and Kennebunk.
Thank you. Representative Morris.
Good morning. I'm Representative Joshua Morris. I represent the towns of Turner, Leeds, and Livermore, House District 75.
Thank you, sir. Representative Pebworth.
Good morning. I'm Sarah Pebworth. I represent House District 133, which is in the Blue Hill Peninsula and includes Brooklyn, Brooksville, Castine, Sedgwick, and Surrey.
Thank you very much. Representative Prescott.
Well, hi, I'm Dwayne Prescott. That's House District 17. That's Waterboro and part of Lyman.
Thank you, sir. And Representative Rader.
Hi, I'm Representative Amy Rader. I represent District 125, which is a portion of Bangor.
Thank you. And Representative Warren, please.
Good morning. Thank you. I'm Representative Sophia Warren, and I represent Scarborough Coastal District 29.
Thank you very much. As I mentioned earlier, we do have a clerk working the system for us this morning. That is Alyssa Thompson, and we'll also be joined this morning by our analyst. I refer to in my mind as Mr. Knowledge, Steve Langland. So thank you very much. So as I open this morning's hearing, the first bill we will be hearing is LD 137. So I will now open that hearing. And with us this morning I just set my bills to the side, of course. Sure I did. All right. So LD 137 is an act regarding the absence from work for emergency response. And that is being presented by Representative Grahowski. Is Representative, good morning and welcome.
Good morning. Thank you so much. Excited to join your committee this morning. My name is Nicole Grahowski, and I appreciate the opportunity to speak to you all in support of LD 137, an act regarding absence from work for emergency response. So this bill is essentially an errors and omissions bill to improve upon the work of this committee in the 129th legislature. At that time, I presented LB 1319, which was titled An Act to Prohibit Employer Disciplinary Action Against Firefighters and Emergency Medical Services Persons Responding to an Emergency. This committee voted unanimously ought to pass as amended, and the governor signed the bill into law. So just for a little bit of background, for those of you who were not on this committee in the 129th, or like me, perhaps didn't remember every single bill you worked on 2 years ago. So the problem that this bill was trying to address is that over the last 3 decades, the ranks of Maine's volunteer firefighters have declined from 12,000 to around 7,000 people. And EMS services have faced a similar downward trend. With the decreasing number of volunteers, especially in communities that cannot afford to pay full-time emergency responders, we must make it easier for our firefighters and EMS personnel to respond to emergencies in their communities, regardless of the time of day. As a former volunteer firefighter who was always supported by my employers for responding during working hours, I was surprised to learn from some of my constituents that many employers do not allow their employees who are also firefighters or emergency medical services personnel to leave work to respond to emergencies. I wondered at that time if there was something we could do differently that would work for responders and also their employers. So back in 2019, when I introduced LD 1319, I came to that legislation by reviewing other New England state statutes regarding emergency service response. And I found that Connecticut had a statute that protects response during working hours. So I modeled the bill LD 1319 after that statute And I asked fire and EMS experts here in Maine to review and suggest any revisions to make it applicable here. The Maine State Federation of Firefighters, the Maine Ambulance Association, the Maine Municipal Association, and other regional fire associations testified in support of the proposed legislation 2 years ago. So for a little bit of background, prior statute protected a firefighter from discharge or disciplinary action by an employer when the firefighter is absent from work at the beginning of the workday while responding to an emergency. LD 1319, which is now law, extended that protection to emergency medical services personnel and also to fire and EMS responders who leave work during regular working hours to respond to an emergency. The law includes appropriate notification of absence to the employer, allows an employer and an employee to enter into a written agreement about procedures to follow if the employee is called to respond to an emergency, and provides that an employer may charge the lost time against the employee's regular pay or available leave time. The law aims to strike a fair balance between our first responders and their employers, recognizing the significant public safety benefits and community cost savings that our volunteer responders provide. It acknowledges that the unknown timing of emergencies and thus employee response will affect a business's operation and provides options to lessen those effects. So fast forward to today, LD 137. This is a bill to improve upon our work in 2021. So in my review of this law with local fire departments and in advance of this hearing, I found 2 errors and omissions, one of which is captured in this bill language and the other I propose to you as an amendment. The law is effective only if the employee presents a copy of their emergency services department's written policy that describes the circumstances under which they will be called to respond and that they will be released as soon as practical to return to work. The law says the employee must do this within 30 days of employment or within 180 days of the effective date of the law. This means that only those people who are already serving as fire or EMS personnel when they took a new job would be covered, but not those who already have a job and decide during the course of their employment to serve their communities in these emergency response roles. Thus, I propose to change the language so that the policy must be provided within 30 days of the employee notifying the employer of their status as a fire or EMS personnel. I also propose to remove the 180-day restriction since it would nullify the above proposed change. Additionally, some fire chiefs shared with me that their members were hesitant to avail themselves of this statute until they heard from others how those conversations with their employers went. So this indicates to me that the positive effects of this law may be slow to be realized throughout the state. I will add that I have not heard any negative feedback about this law that was passed 2 years ago. Additionally, as I was rereading the section of statute, I noted that an amendment to LD 137 is needed to correct the omission of, quote, emergency medical services persons, end quote, to subsection 6 to read, and this is in my written testimony, so it might be easier. Basically, striking where it says firefighter status and replacing that with status as a firefighter or emergency medical services person. That way, both groups which are covered in the whole rest of the statute are covered in this subsection as well. I think it was merely an omission of the time. So in conclusion, I want to thank you all, this esteemed committee, for considering this bill to improve upon the legislature's efforts last session to make it a bit easier for firefighters and EMS personnel to serve our communities. I hope that by improving upon our efforts to secure employment for firefighters and EMS responders, we can help decrease their emotional stress and let them focus on what really matters, which is keeping us all safe. So thank you so much for your time again, and I'm happy to answer any questions you might have.
Thank you very much, Representative. We have one hand up. Representative Drinkwater, please, sir.
Thank you, Mr. Chair. Good morning. You mentioned about on page 2, improving upon our work in 2021. You mentioned that make a copy of their department's written policy. Have you done or heard from different departments across the state? I'm wondering if a lot of the smaller departments do not have such a policy. Is that something that is mandated, Or is that something you have numbers on?
Thank you so much for the question, Representative Drinkwater. Actually, what we did working with those associations that I mentioned and their legal counsel, we drafted a model policy. I did with them to provide to those departments to use in order to take advantage of the statute. And that, as I understand, was distributed through the Organization of Chiefs, because we have a really great communication network here that connects all the fire departments. And I know that many of the counties have their own chief meetings, and I went and presented at the Hancock County one, for instance. And so my hope is that model policy that we drafted, where they can just literally insert their department names and any specifics that might differ, has been distributed statewide. But certainly I would, after this bill would pass, hopefully, and take the 180-day restriction off, then I certainly would check back in with those departments and make sure they have the current information and everything they need.
Thank you.
Thank you very much. Representative Bradstreet, please.
Thank you, Mr. Chair. Thank you, Representative, for bringing this to our attention. I remember this bill somewhat from last session. Are you finding that from the firemen or the emergency personnel that you've been talking to, that the current bar of notification is a little too high? Is it not reasonable? Is that what you're hearing?
In terms of notification to their employer, or to
their employer,
that they are indeed a firefighter or an EMS personnel?
Yes.
Or you mean notification of when they're actually responding?
Well, that the 30 days is not reasonable.
I think the 30 days, I think that's a great question. I didn't receive any specific feedback that once the conversation had happened, that 30 days was not enough time to get the policy to the employer. The feedback I received was, firstly, what if somebody's already got a job and then they become a firefighter? The way the bill was written precludes them. So that was a problem. And additionally, I think some folks are hesitant, especially in the environment that we're in now, to have these conversations. But my hope is, as they see them being effective with other members over time, that more people that feel that they need this protection will take advantage of it. So I think it's good to open it up a little more.
Thank you. Appreciate it. Thank you.
Thank you both. Any other questions for Representative Grohowski? Seeing none, thank you very much for being here today, sharing your testimony and thoughts, and being available for us regarding any questions.
You are welcome. And just so you know, I didn't recruit a lot of folks to come after me this time, because I think they're very busy taking care of our health, and I didn't want to distract them from that for just a simple errors and omissions style bill. So
we appreciate that very much. I think it's pretty straightforward, and you made it very clear as to what you're seeking. Representative Bradstreet, do I see your hand up, or is that just, I'm sorry, I don't want to overlook it.
You see it up, but it should be down.
Oh, okay.
Sorry
I just didn't want to look at it. That's okay.
It's Monday.
Okay. Well, I'm getting a message that there are no other testifiers here with us today, but again, thank you very much, Representative. You have a great day. So just to clarify, there are anyone to speak against the bill? And I know the answer, but I'll ask it anyway. And are there any speakers neither for nor against? Well, hearing and seeing none, I will call the hearing relative to LD 137 closed. Next up on our agenda is LD 248, an act regarding the Board of Occupational Safety and Health. Before we get into that LD, I'm going to pass the gavel along to my co-chair, Representative Sylvester, as I will be testifying on behalf of that bill. Thank you, Mr. Sylvester. Chair is yours, sir.
Thank you, Senator Rafferty, and I will give you the podium right back in order to testify on LD 248.
Thank you. LD 248 is an act regarding the Board of Occupational Safety and Health. And I just wanted to say, Representative Sylvester, thank you, and members of the Labor and Housing. I'm here today to speak in support of LD 248, an act regarding the Board of Occupational Safety and Health. It is the intent of this bill to allow the Board of Occupational Safety and Health the authority to adapt emergency rules. It is meant to do so by eliminating the current requirement of a 90-day waiting period in order to do so. And I think it's clear in my mind, but I am willing to entertain any questions you may have with the assistance of representatives from the Department of Labor, as they are the experts in this area.
Thank you, Senator. Are there any questions for Senator Rafferty? Seeing none, looks like you're off the hook easily today, Senator.
You're just being too kind to me. Thank you.
Next up on our list, I see Jeff McCabe from MSEA to speak in favor. Is Mr. McCabe in the? I know he had sent a note saying he was going to be back and forth. There he is. Very good. Mr. McCabe, are you there? You are muted and your video is off if you are.
You folks hear me all right now?
Yes, we can, Mr. McCabe.
Great.
Oh, there you are.
Sometimes
perfect.
that transition sometimes from the waiting room into the hearing sometimes can be a little stressful in a moment of panic there. So, but good morning, Chair Rafferty, Chair Sylvester, members of the Committee on Labor and Housing. My name is Jeff McCabe. I am the Director of Politics and Legislation for the Maine Service Employees Association. I'm here today in support of LD 248. As you've heard from the bill sponsor, this bill simply allows for the creation of rules and standards. In reviewing this bill, we felt that this would help in addressing what we think could be a more efficient and standardized way to create rules during a future pandemic. That's pretty much what I have today, and happy to answer any questions. Just wanted to be here and show support of this bill.
Thank you, Mr. McCabe. We appreciate the short testimony and simple explanation. It looks like Representative Drinkwater has a question for you.
Thank you, sir. Nice to see you again, Jeff.
Good to see you, sir.
Educate me on this. I mean, to me, this looks like we are, as legislators, saying, let's defer our responsibilities to the OSHA. Just educate me on that. Are we saying let's turn over our responsibilities to a rulemaking agency such as OSHA?
Thank you for that question. One of the things I was thinking about in creating this testimony is that probably the committee might not have had an overview in regards to BOSH here in the state of Maine. And that might be something that might be helpful for part of the work session. And I think that this is actually the state board that we're looking at here. So I understand sort of the concern if you're thinking of federal OSHA. But in our experience, what we saw in the beginning of the pandemic was many agencies and work sites sort of trying to create, standards of their own. And there was a duplication of those efforts. And at times it created sort of a lack of clarity. So that's sort of our experience. I think it also led to, sort of a delay. And while the folks that we represent are essential workers and continued to work during the pandemic, there was times where those standards probably could have been clarified a little bit more. And I think what we could probably do for the work session, and maybe DOL could come forward, is to just sort of provide an overview of the Bureau of Occupational Health and Safety for the committee, or Safety and Health.
I think that would be helpful. Thank you very much.
Yeah, thank you for the question.
Representative Bradstreet.
Yes, thank you, Mr. Chair. Thank you, Mr. McKay, for being here again. Actually, I'm kind of questioning whether, are we going to have the department testifying later on this?
We will. We will. We have both
I-
Jeffrey Young and Mike Rowland from
Okay,
the director.
fine. Then I really don't have any questions for Mr. McKay, but the point that Representative Drinkwater made, I think is a very good one. Thank you.
Yeah, thank you for the questions. I will try to sign up later in the queue next time so that I'm after all those folks.
Are there any other questions for Mr. McCabe? All right then, sir. We will see you next time.
Thank you.
Next up is Jeffrey Young, and then he'll be followed by Director Rowland from DOL. Welcome, Jeff.
Good morning. I'm wondering if it might make sense for the committee to first hear from Mike Rowland. I'm happy to defer to him.
Often we use the department as a backstop against questions that come up during the other testimony, so that they can sort of hear everything and sum us up and or seek information for the work session. So I think you're all set, Mr. Young.
Okay, very good. Thank you, Senator Rafferty, Representative Sylvester, and members of the committee. My name is Jeffrey Neal Young. I am an attorney with Solidarity Law here in Maine. I have been practicing in Maine for 30 years as an employment and civil rights lawyer, and 40 years altogether. I am simply testifying in my behalf this morning because I wasn't entirely clear what the purpose of the bill was. Having now heard Senator Rafferty's testimony, I support it, and I think an organization that I'm part of, the Maine Employment Lawyers Association, likely will submit written testimony in support of it. But I do think that it's important that Bosch have the opportunity or be able to promulgate emergency regulations given the pandemic. Thank you.
Thank you, Mr. Young. Are there any questions for Mr. Young? Seeing none, have a wonderful day, sir.
Thank you.
And next up, we have Director Rowland from the DOL.
Hello.
Welcome, Director Rowland.
Oh, hi, thanks. It's my turn. Jeff McCabe is right. There's a nervous moment there for about 5 seconds where I don't know where I am, but apparently I'm here. Am I here?
You are here, sir. Thank you for being here.
Is it my turn?
It is your turn. Yes, indeed.
Okay. And I have to say, to preface, you have our written testimony, our printed testimony, and I'm going to truncate that slightly so that I can fit this in without reading incredibly fast.
Okay, very well.
Okay. So greetings, Senator Rafferty, Representative Sylvester, and members of the Joint Standing Committee on Labor and Housing. I'm Mike Rowland. I'm the director of the Bureau of Labor Standards at the Maine Department of Labor. I'm here today to speak on behalf of the department in support of LD 248, an act regarding the Board of Occupational Safety and Health. If passed, the Board of Occupational Safety and Health would be able to promulgate emergency rules. Currently, this board is the only rulemaking authority within Title 26 without emergency rulemaking authority. Little background: in August of 2015, the state of Maine was declared an OSHA state plan for state and local governments only. The Maine state plan for state and local governments receives annually over $500,000 in federal funds since that time. Maine statute separately grants Bosch the authority to adopt rules assuring safe and health working conditions for state and local employees, and requires that at a minimum, those rules conform to federal standards promulgated by OSHA, the Occupational Safety and Health Administration. Federal law requires these rules be enacted within 30 days of adoption by OSHA, and failure to comply with that requirement could put our federal funding at risk. Currently, however, such rules cannot be quickly adopted. The statute states that rules adopted by Bosch shall not become effective sooner than 90 days after adoption, and provides no authority to enact emergency rules. Therefore, under present circumstances, Maine is in danger of failing to fulfill its obligation as a state plan and at risk of losing significant federal funding designated for that purpose. The proposed bill seeks to remedy this restriction in order to enable the board to promulgate emergency rules. As a result of the pandemic caused by COVID-19, the department reviewed our processes and our ability to respond in order to protect the safety and health of public sector workers. If emergency temporary standards were enacted by OSHA, Bosch would be unable to adopt rules within the required time, and the department would be unable to enforce them. So that's what we're seeking to remedy. Thanks for your time and attention. I'm happy to answer questions, and certainly will appear at the work session if you so desire, and bring other staff if that helps to explain in greater depth why we've requested for this adjustment to be made. So thanks.
Thank you, Director Rowland. Appreciate your testimony today. Looks like Representative Bradstreet has a question for you.
Mm-hmm.
Yes, thank you, Mr. Chair. And thank you, Mr. Director Rowland, for being here again. I think it was recently we had another bill that was proposed to us, needed to satisfy legal requirements for something, and then we had testimony that wanted to add to that, which caused a little bit of question on the part of the committee here as to not whether we should adopt it with or without that amendment. Are we able to to adopt the federal rules that they require? It says at a minimum that would do that and nothing more than what the federal government requires?
We are, yeah, that would be the purpose, our purpose, in adopting rules responsive to the pandemic or any other situation that might require an emergency measure.
All up, Mr. Chair.
Yes, indeed, Representative Bradstreet.
She would be able to bring those rules to us and show how they comply with the federal requirements at some point in time.
Yes, we would. Okay, yeah, on request, we'd be happy to. We'd be very happy.
Thank you.
Yeah,
appreciate that. Thank you.
Representative Prescott.
Oh, well, thank you. I understand the intent of the bill is for emergency purposes. I'm just curious that we're scratching out the 90 days in the existing law. So is that going to wipe the 90 days out for even non-emergency situations?
No, the adoption of emergency rules is a special situation that's permitted in I think it's Title V of Maine statutes. But ordinarily, the adoption of regular rules, takes a period of months. There are public, testimony opportunities, hearings, sometimes if warranted, and it's a longer process, and there's a long period of public comment and consideration. So ordinarily, we would not seek, and we don't seek to adopt emergency rules, and this bill would only allow us to do that in emergency situations.
All right, thank you.
Yeah.
Representative Drinkwater.
Thank you. is there somewhere in the title, I think you said Title 5, is there somewhere, I guess my question is, what is the definition of an emergency? Because, everybody would have a different definition of an emergency.
Right.
Obviously, pandemic is an emergency. I guess I would like to see some more information on what the department defines as an emergency.
I'll get that for you, and I believe it's in statute. It's not so much subject to our interpretation, but according to the law, and I'll get you what the background on that that you need by the time the work session comes around.
Thank you.
If that'll help. Yep. Mm-hmm.
Are there any other questions for Director Rowland? Director, I have a quick one. It's more really just a summary of your testimony. I know we have it written, but I wonder if you could just very simply explain, we're in an emergency, what the timeline to make a policy change is now versus what it would be should this legislation be successful. Just to sort of spell it down to its crystal components here.
Yes, emergency rules are adopted within a very short period of time. I think it's almost immediately, and they are temporary. According to Title V, I believe 3 months. And then within that period of time, regular rules can be adopted. And in my experience, and there is a rigid timeline, but usually the timeline is the most optimistic time period in which the rules can be adopted, and there are delays along the line. In my experience, it takes between 3 to 6 months to formally adopt a rule change or a new rule. And OSHA, under normal circumstances, the Board of Occupational Safety and Health will adopt rules according to the changes that OSHA makes in its standards. And because the board needs to meet and vote on them, it takes, I'd say, at least about 6 months in order to make the rule changes that are necessary. But that kind of conforms to the federal schedule of a lengthy process to adopt standards in normal circumstances. But OSHA has emergency provisions so that it can adopt standards quickly, and that's what we're seeking to do to be able to reciprocate in a situation like that, which we don't anticipate. I guess nobody anticipated the pandemic, or if they did, they were smarter than me. And so we don't anticipate such a situation to occur anytime soon. But this last year has made us aware that if there were to be such an emergency and OSHA responded quickly, we would be kind of on the back foot as far as our ability to respond quickly. So we can talk more about the normal and emergency rulemaking processes at the work session if you like. We'll certainly be prepared to do that.
Okay, thank you. We appreciate that. Representative Pedworth.
Thank you, Mr. Chair, and thank you, Director Rowland. My question is just to clear up some confusion. Is this a change in the federal OSHA laws, or have we been sort of out of compliance, except that there hasn't been an emergency? Can you help clarify for me?
Yeah, we have not been out of compliance because OSHA, the federal agency, has not adopted temporary emergency standards, which it might have during the past year, has not. We anticipate the possibility that the new federal administration might adopt temporary emergency standards in response to the pandemic, but we can't be sure. We can't be sure at this point. We just want to be prepared.
If I could follow up, Chair.
Of course.
Okay, but OSHA laws should be implemented within 30 days.
Mm-hmm.
Federal OSHA laws.
Mm-hmm.
And we can't do that in Maine because we have about a 90-day implementation timeline.
We do under current statute, yes.
And so we're looking to change that so that we can align with the federal law.
Adopt as quickly as we need to. Yeah.
Okay, thank you.
Okay. think you're muted, Mike.
Thank you, Director Rowland. We appreciate you being here today, and we probably do look forward to hearing a little further discussion about that, as well as what the difference is between jurisdiction of federal OSHA and BOSHA. I think that would also be helpful. Probably not a detailed, but at least an overview.
Happy to do so.
Okay, thank you very much.
Thanks.
That is all the testimony that I have. Alyssa, do we have anything else? Anybody else?
No, not for this bill.
All right, then thank you very much. That concludes then the public hearing of LD 248 and opens the public hearing for LD 305, an act to include forest rangers and forest fire prevention specialists in the Bureau of Forestry's Forest Protection Unit in the laws concerning cancer suffered by firefighters. And the sponsor of this bill is Senator Scott Searway of Kennebec.
Senator Searway had signed up, but I'm not seeing him in our list of attendees.
Melissa, could you give Senator Searway a call?
And
does he
sure.
list a number to reach out to him?
I don't have his number, but I can find it real quick. It'll just take me a minute.
Okay, why don't we take a 3-minute break? Let Alyssa find Senator Searway, and then we'll be back at, it's 10:44. Let's be back at, before 10:50.
Representative, I am a co-sponsor on the bill. If it becomes necessary, I'll present it, although I don't have a lot of detail.
I appreciate that. And I think we've got a few folks to testify here.
Good.
Representative Sylvester, are you there or did you step away?
I am here.
It didn't even ring. I got his voicemail right away.
I contacted, he will be with us shortly.
Oh, wonderful. Thank you.
It's good to be handy at something.
Thank you, Representative Bradstreet. All righty, it is 10:50. I think that what we will do is give another minute for folks to get themselves situated, and then we'll take you up. I do not see Senator Searway amongst the participants, so I think we will take you up, Senator Marymount, on your offer to offer your co-sponsor. Oh, he is coming in as we speak. Welcome, Senator Searway.
I'm having a little technical difficulties.
That's okay, sir. You're currently in an oval, but we can see you loud and clear.
The Zoom and then so I tried to print the speech out and it won't print for some reason.
Okay.
So if you can go to the next one and I can come back, and I don't know if you can do that.
We certainly can do that, Senator Searway. We've got Senator Marymount, who's a co-sponsor here, ready to testify. So why don't you go and take care of that? We'll leave you as an attendee here, and then you give me the thumbs up when you're ready to go.
All right, thank you.
All right, thank you, Scott. Senator Marymount, we'll call you to the podium.
Thank you, Mr. Chair. The bill seeks to do what others that we will be seeing and have seen are already trying to do. We've identified areas where certain individuals who are actively involved in firefighting and who are having the effects from firefighting on their health, both in the short term and long term, these folks have been left out of some of the protections that everyone else enjoys. Because of that, these bills are coming to just add them. They're not new classes. They're not anything extreme. Leaving out someone based on gender or because their title is a little different, but there they are in the heart of the smoke, of the fire, of days of working on this, hours that no one would ever do in a job unless it was protecting other folks and the environment. It just speaks to their commitment and what our commitment in return should be. But again, it doesn't add new groups, or is it an extreme position to take? And the last little piece, I'm stalling for time slightly for Senator Searway. If you know all of us, Senator Davis, Senator Searway, and I, to all be on the same bill is like the earth stood still. So you can just tell how bipartisan this is and how it seeks to address a shortcoming that we've found. And that's all.
Thank you, Senator Marymount. Are there any questions for Senator Marymount? Representative Bradstreet.
Yes, thank you, Mr. Chair, and thank you, Senator. Just a clarification. So basically, this is dealing with a rebuttable presumption under the workers' comp laws. Is that correct?
Ooh,
in essence.
Let's give that one to someone who can answer it as new person to labor.
Okay.
Please.
Okay, fair enough. Thank you.
Thank you.
That is my understanding, Representative, but we do have some folks coming up from workers' comp later, and the sponsor probably will be able to answer that when he's prepared as well. So what I'm going to do is we will move. Oh, you are muted, Senator Searway. You're still muted, sir. All right, so.
Can you hear me now?
There you are, Senator.
Okay.
Were you able to fix your printing problem, sir?
Yeah, I'm trying to. Yeah, can you hear me?
We can hear you, Senator.
Okay, I can read it. I don't know if you can see me or not.
We can see you. We're all set to go.
proposal, so. Are you ready?
Yes, sir. Go ahead.
Okay. Good morning, Senator Rafferty, Representative Sylvester, and members of the Labor and Housing Committee. I'm State Senator Scott Searway, and I represent Senate District 16, which includes Albion, Benton, Clinton, Fairfield, Unity Township, Waterville, and Winslow. I am before you today to present LD 305, an act to include forest rangers and forest fire prevention specialists in the Bureau of Forestry's Forest Protection Unit and the laws concerning cancer suffered by firefighters. In 2009, a change was made to the Workers' Compensation Act to include a presumption that firefighters who contracted cancer as a result of their firefighting duties would be included. Today, the law covers active duty firefighters, those employed by the State Fire Marshal's Office, and active members of the Volunteer Fire Association. We are all aware that firefighters have a dangerous but out of control campfire, house fire, or forest fire. The risks associated are many. One risk comes from the exposure of carcinogens, which can lead to cancer. Over the last decade or so, cancer amongst firefighters has become a more broadly discussed topic, both at the State House and even in the local newspapers, as you read obituaries after obituaries of firefighters who have lost their life to a battle with cancer. Studies conducted by the National Institute for Occupational Safety and Health show that firefighters have 9% increase in cancer diagnosis and 14% increase in cancer-related deaths than members of the general U.S. public. Not included in current law are Maine forest rangers and forest fire prevention specialists who also play a critical role in fighting fires. These men and women keep us safe as they fight fires here in Maine. And at times, they are responded to over 2,220 fire investigations. Many times the cause of the fire is unknown, so as they go to investigate them and put them out, they are coming into close contact with recently suppressed materials such as plastics, tires, vehicles, etc., that emit harmful toxins. This legislation simply adds forest rangers and forest fire prevention specialists to Title 39A, subsection 328-B, so that they can receive the same attention other firefighters receive when faced with cancer as a result of the strongly consider supporting this legislation, and I am happy to answer any questions you have, but would note that you will be hearing from those in the firefighting profession today that will likely be able to provide you with even more information. Thank you.
Thank you, Senator. We certainly appreciate you bringing this bill today and testifying. We appreciate you being here. Does anyone have any questions for the good senator? Well, apparently you did such a good job, Senator. Everyone understands the bill. So well done. That doesn't happen a lot. So we thank you for being here and your availability at the work session.
Right. Thanks.
All right. So I believe that, are there any other co-sponsors waiting to testify? Alyssa.
Not that I can see. Hold on, I'll just have to double check 'cause there's several of them. No, I don't see anybody hanging out in the Galley.
Perfect. All right. Well, then we will go to Ben Goodwin, followed by Daniel Turlot, and then Jeff McCabe. Oh, I'm sorry. And then Jeff McCabe. Welcome, Mr. Goodwin.
Good morning.
Good morning. Did you want to turn on your video, or were you?
Oh, I can. Let me see if I. Good morning. There we go.
Sir. Perfect. The floor is yours.
Great. Good morning, Senator Rafferty, Representative Sylvester, and the Labor and House Committee. My name is Ben Goodwin, and I am a District Forest Ranger for the state of Maine. I'm here testifying on my own accord, and I do not represent my agency here today. I tell people all the time that I am living the dream, and that is true. There are not many people that can say they love what they do, but I am one of them. I have been a forest ranger for 10 years, and I have been a Down East district ranger for the last 2. I'm very proud to wear my uniform and serve my state. I looked into other careers at different law enforcement agencies, but chose to be a forest ranger because it allows me to be more proactive and not reactive to protecting the people of Maine. Now you have the chance to be proactive in helping protect the rangers of this great state. Being a supervisor, I believe one of my main responsibilities is to make sure my rangers go home safe to their families every night. We all know that being a ranger comes with some degree of risk, but I believe this bill will help protect and give peace of mind to the rangers, knowing they will be covered if they should get cancer for serving their duty. You have or you will hear about rangers fighting wildfires. I would like to discuss a part of our job that poses a high risk factor for cancer, which is the enforcement of the open burning laws. This, I believe, is where we're most vulnerable to the toxic chemicals that can cause cancer. One of our top burning violations is burning unauthorized material. These unauthorized materials can consist of plastic, styrofoam, lead paint, motor oil, tires, fiberglass, just to name a few. You name it, and I would guess that one of our rangers has seen someone try to burn it. This is where I feel our rangers are most exposed to the carcinogenic chemicals that can cause cancer. As law enforcement officers, our duty is to go to these calls and stop the burning of these materials as soon as we can to help protect the surrounding people from the toxic smoke. I have been to many of these calls where someone is burning a pile of tires or an old boat. And I have tried to do my best to mitigate the risk of the exposure. But now as a supervisor, I have to send my guys to these calls knowing that they will be exposed to these chemicals and what that could do to them short-term or long-term. It's that long-term exposure that I believe that this will help mitigate. If you should support this bill, it would not only show your appreciation to all the Maine State Forest Rangers for what they do and the risks we take to protect the people and resources of Maine, but it would also give us all mental and emotional comfort to know that we'd be protected and covered by you if we should ever get diagnosed with cancer. Thank you for your time. And if you have any questions, I would be happy to answer them.
I've noted before that fire personnel always come in under or right on the button. So we appreciate that, Mr.
Wasn't
Goodwin.
bad. No problem.
All right. I see a question from Representative Drinkwater.
Yes, thank you. And thank you for sharing your testimony with us. My question to you would be, does the department require a yearly cancer screening? And if the department does not require it, does your workman's comp require it?
Our department does not require it. And I'm not sure about workman comp, but I don't believe they require it either. But I'm not sure on the workman's comp side.
And lastly, don't you think we need to do more education to the public on what to burn and what not to burn?
I think that would be a great idea. Like I said, being proactive is a big part of our job. I think the better we can do to get out in the public what they should burn and shouldn't be burning would be great.
All right. Thank you very much.
Thank you.
Sounds like a great emergency session bill, Representative Drinkwater, and you can bring that over to me to sign. Are there any other questions for Mr. Goodwin? Seeing none. Thank you, sir, and we appreciate your service.
Thank you. Have a great day.
Next is Daniel Tortolot. I see him coming into the
Good morning.
Good morning, sir. How are you today?
Very fine, thank you.
You're free to begin whenever you're ready.
Okay, I will. Thank you. Senator Rafferty, Representative Sylvester, and members of the Labor and Housing Committee. My name is Daniel Turtelot, and I am the Executive Director of the Maine State Law Enforcement Association, which is a labor group that represents forest rangers. I'm here today to testify in support of LD 305, an act to include forest rangers and forest fire prevention specialists in the Bureau of Forest Protection unit in the laws concerning cancer suffered by firefighters. Going back in time, during the 127th legislative session, Senator Bill Diamond submitted LD 125, which is an act extending workers' compensation benefits to certain employees of the Office of the State Fire Marshal's Office who contract cancer. This bill was ultimately approved by this committee and passed into law by the 127th. In retrospect, MSLEA, that's us, erred by not having included the firefighters of the Forest Protection Division in LD 125. Since 2015, and I'm going to back up and just step away from my testimony and say that at that particular time, I guess I'm going to take some of the blame. We didn't do the background on that bill to see that forest rangers should have been included to it based on the science. But since 2015, there have been a number of studies related to wildland firefighters that clearly show that the same health risks exist for our forest rangers that exist to firefighters currently included in presumptive cancer law Title 39A 328, Section 328B, cancer suffered by firefighters. The need for this protection has been applied to all other Maine firefighters, making personnel of the Forest Protection Division the last firefighters to be added to the law. I would like to thank the committee again for their consideration of this important bill, which gives recognition to the serious and dangerous work conducted daily by our Maine forest rangers. I'd be happy to answer any questions. And if I could, I'd like to respond to the question about the annual testing. And in fact, a piece of the fire marshal bill, not the bill, but a piece as a result of that, there was an expanded screening process that was put into play. And I think it's Representative Drinkwater's question was put into play. So that's something that we would be moving to do for either through negotiations or in setting down with the administration of the Forest Protection Division. Thank you very much.
Thank you, Mr. Tortolot. Are there any questions for Mr. Tortolot? I wonder, it's possible that somebody else in their testimony will provide us links, but some of the studies that you referenced, if you were able to make those available to our analyst for the work session, that'd be fantastic.
I do know there's going to be a reference made to them in other testimony, but anything that we have that we didn't feel like we got to you, and then certainly we'll send them into the committee. Thank you very much.
Very good. It's part of my job, sir, to make sure that stuff gets going. I figured that somebody was coming up with it later, but
Okay.
We appreciate you being here today, and it's good to see you as always, Dan.
Okay, thank you.
Next, we have Jeff McCabe back to see us.
Morning again, folks. I'm hoping you can hear me okay.
Yes, indeed. We can't see you, but we can definitely hear you.
Okay, excellent. We'll start with that then and see if last time it prompted me on sort of my end to allow video. So just using, there we go. Came up again and then it went away. So I will just start without the video, and I apologize for the video not being up, but there we go. Chair Rafferty, Chair Sylvester, members of the Committee on Labor and Housing. Again, my name is Jeff McCabe. I am the Director of Politics and Legislation for the Maine Service Employees Association. I am here in strong support of LD 305. As you've heard before, this bill simply adds forest rangers and forest fire prevention specialists. I've sort of thought long and hard about the individuals doing this important work for the great state of Maine, and the lack of recognition that they deserve at times. And sometimes they haven't always had the support that they need. These individuals pride themselves on modernizing technology, keeping well trained, and being well networked with those in other states doing similar work. It has seemed to me that while many advances have been made in the line of work as far as training and technology, few things remain the same. This work is dangerous and very physically demanding. It also exposes these individuals to harmful chemicals and particulate matter. It is very important to also remember that these folks don't just deal with things that you find in the natural world. The line between forest and civilization is not clearly defined in this work. As you think about this bill, you might even have images generated in your mind of these folks fighting forest fires, wearing only a bandana over their nose and their mouth while wearing a bright yellow shirt. I would suggest that you take that image and go beyond just that in your mind, but picture the same individuals, bandana-clad individuals, fighting a fire, protecting a hunting camp, a lakeside summer cottage, or even a subdivision of new homes on a forested hillside, protecting lives and property while only wearing just that bandana-type covering. I'm happy to bring more information back to this committee if you have questions. I've included additional information below that I think you will see the science clearly supports the bill before you today. You may see other aspects that will be helpful to understand the important work that these individuals do. We urge you to support LD 305, and I thank you, and I'm happy to take any questions. And I believe you have my testimony that shows several links with scientific data, and I believe you'll also see a quick reference publication from the Oregon State OSHA, which is a very well done sort of 2-page PDF that just makes you think a little bit more about this work and the types of things that these folks are exposed to. So with that, I'm happy to take any questions.
Thank you, Mr. McCabe. I see a question from Representative Bradstreet.
Thank you, Mr. Chair, and thank you again, Mr. McCabe. We heard in previous testimony that the 127th legislature enacted the first laws covering this type of situation, but inadvertently there was a group left out, and this would address that. Are there any other groups out there, to your knowledge, that may eventually want to come under the parameters of this bill?
Thank you, Representative, for the question. I can't think of anything. You know, I know that you had a bill last week having to do with, you know, defining, you know, certain types of cancers in statute. You know, so I think that these issues pop up from time to time, and I'll be honest, you know, we are trying to coordinate better with others so that we're tracking these issues at sort of the same time. For us, we have some of the supervisory folks that do this type of work. And then beyond that, we also have sort of a unique unit at the Bangor Fire Department, which are our military firefighters, separate from this issue. But, you know, that's a group that I think at times, last year, you're familiar with the overtime compromise that we came up with. We really cast the net far and wide on that to make sure that we were working with the other bargaining agents and that we are coordinating, you know, better than maybe we have in the past. So while not directly related to this issue, you know, I take it upon myself to try to talk with folks about these issues more, but sometimes these are not always on all of our radar. So we're just trying to do a better job of picking up on these when they come up and include others.
Okay, thank you.
Are there any other questions for Mr. McCabe? Seeing none, thank you for the link, sir. We appreciate your testimony today.
Thank you. Headed back to criminal justice.
All right, have safe travels.
Thank you.
As I believe that was the last of the testimony in favor. Is there anyone here, Lisa, who's ready to testify against the bill?
We have two more in favor.
Oh, two more in favor.
Yes, we have
Okay,
Lisa
good.
Byers and then William Barnum.
Okie dokie. I don't have them on my list. All right, go ahead. You could just bring them in and introduce them. That'd be great.
I have Lisa in here. Lisa, I don't know if you can turn on your camera.
Good morning.
Good morning, Ms. Byers. How are you?
Good. And you?
I am excellent. Thank you. You are ready to begin whenever you are.
All right. Good morning, Senator Rafferty, Representative Sylvester, and Labor and Housing Committee. I'm here on behalf of the Maine State Law Enforcement Association and Maine's Forest Rangers. My name is Lisa Byers, and I have been employed by the Maine Forest Service for 15 and a half years, and this is my testimony and not that of the Maine Forest Service. I'm here today to request employees of the Maine Forest Service who are working in a position where they respond to fires be added to the Presumptive Cancer Law, Title 39A, 328B, cancer suffered by firefighters. Attached to my testimony is written research detailing the effects of wildland smoke on firefighters. You'll read about the chemical composition and how smoke is made in articles written by Kathleen Navarro, who holds a PhD and fought wildland fires out west. These articles will break down the more exposure to smoke, the higher the incidence of cancer is over a 25-year career. The research will show wildland firefighters, which Maine Forest Rangers are exposed to chemicals such as carbon monoxide, carbon dioxide, polycyclic aromatic hydrocarbons, PAHs, benzene, formaldehyde, and acrolein. These chemicals are found in smoke from forest fires. This does not include the poisons from household goods or plastics. The research on household materials burning is what allowed the fire marshals to be added to the bill in 2016. Maine's forest rangers are exposed to these very same hazards on fires. PAHs are classic compounds consisting of two or more fused benzene rings. They are hazardous air pollutants formed during incomplete combustion and are no mutagens and carcinogens. Past occupational health studies found the exposure to PAHs was associated with a higher risk of lung and bladder cancer and skin cancer from dermal exposures to PAHs. What's incomplete combustion? When something doesn't fully burn. When we put a fire out, we're stopping the combustion process, therefore increasing the incomplete combustion problem, therefore increasing the smoke exposure. Think about when you have burned a candle and it's burning away, smells good, and there doesn't appear to be any smoke. Now blow the candle out, there's a lot of smoke. Now make that candle in the trees and you can extrapolate the smoke release from these new candles, and that is what we're breathing in along with everything else that is burning, which may or may not be a natural material. The National Wildfire Coordinating Group, which are the federal standards we adhere to for training and for safety, has a 236-page manual, which goes along with a class on smoke management on wildfires. This manual has not been updated since 2001, and on page 36 advises benzopyrene, arachnocene, benzene, and numerous other components found in smoke from wildland fires can cause headaches, dizziness, nausea, and breathing difficulties. In addition, they are concerned because of long-term cancer risks associated with repeated exposure to smoke. In summary, it is essential you realize the ranger's exposure to toxic and carcinogenic causing agents is similar to interior firefighters in fire marshal's office. While some of the risks can be mitigated with wearing Nomex for skin exposure and using soap, the utilization of respirators and face masks on wildfires has not reached a point where they are practical while in the suppression stage. Please let me know if you have any questions.
Thank you, Ms. Byers. And I will just say for the record that our clerk, Alyssa Thompson, had cued me that you were there. As usual, she's 3 steps ahead of me. And I don't know why I don't just do whatever she tells me. But someday I'll learn to do that. All right. Well, are there any questions for Ms. Byers? Seeing none, thank you so much for being here and thank you for all your work.
Thank you.
Appreciate you. Next is William Barnum. Welcome, sir.
Good morning.
You're all set whenever you're ready to go.
Thank you. Senator Rafferty, Representative Sylvester, and members of the Labor and Housing Committee.
My name is Will Barnum, and I have served as a forest ranger with the Maine Forest Service since 2005. I'm not here representing my department, but I do wish to share some numbers and experiences that I have acquired during the last decade and a half of public service. I speak to you today to request that employees of the Maine Forest Service Forest Protection Division be added to the Presumptive Cancer Law, Title 39A, Section 328B. Forest rangers are a unique category of public servant. We are a law enforcement agency tasked with enforcing natural resource laws as they relate to forests and forest practices within the state of Maine. But preemptive to our responsibilities as law enforcement, we are wildland firefighters and wildland fire managers. Last year, rangers responded to over 2,200 wildfire law enforcement situations and inspected nearly 3,000 open burning permits, resulting in 829 actionable offenses. Of those violations, 289 were classified as prohibited materials fires under Title 12. Prohibited materials fires are any outdoor fires where waste that is not wood waste is being burned. As a ranger, I have seen just about everything imaginable burned in prohibited materials fires, up to and including kitchen sinks. Household waste, demolition debris, and industrial waste, just to name a few items, are commonly found in the smoldering piles of prohibited materials fires across the state. Rangers also responded to over 1,100 wildfires across the state last year. Of those, 228 involved equipment, vehicles, or structures. It is not uncommon for rangers to assist with structure fires or even be the responsible authority on scene for structures and vehicles, particularly in the unorganized territories of Maine. I cannot expertly speak to the long-term health effects of exposure to the smoke and fumes from these types of fires. I can, however, share my own experiences of exposure. I have responded to many prohibited materials fires where the smoke and fumes were noxious enough to make me feel sick to my stomach, and on some occasions made me feel ill for hours or even days after the response. As rangers, we do our best to stay upwind of the fires and avoid breathing in the airborne pollutants as much as possible. But inevitably, during suppression, evidence collection, and investigation, fumes are inhaled and particulate matter is ingested. I think it is also worth noting the number of wood-burning fires that rangers respond to, and recognize that while the concentration of chemicals are probably less than those of what has already been discussed, rangers are still breathing smoke for extended periods during those situations as well. At certain times of the year, rangers can be on site for multiple fires per day, and during peak fire season, they may be fighting fire for days or weeks at a time. This long-term exposure is far beyond what most people experience and undoubtedly has health impacts. I ask you to consider those impacts and the others I have mentioned and strongly urge your support of adding employees to the Maine Forest Service Forest Protection Division to the Presumptive Cancer Law, Title 39A, Section 328B. Thank you for your time and consideration, and I would be happy to answer any questions that you may have.
Thank you, Mr. Barnum. I see Representative Bradstreet and then Representative Drinkwater.
Okay, thank you, Mr. Chair, and thank you, Mr. Barnum, for all that you do and for being here today. I'm wondering, in light of all the experiences that you've had, and I'm actually going to follow up on a question that Representative Drinkwater asked previously. Do you often undergo cancer screening or other types of health screenings in light of the type of work that you do that may be above and beyond what a person with a normal job would do?
I have not undergone any cancer screenings myself. We do have an annual fitness program to maintain what's considered to be an arduous level of fitness for wildland firefighting standards. But beyond that, there's nothing required by the department or Department of Labor that I'm aware of for us to be screened.
Okay, thank you. Appreciate your answer.
Representative Drinkwater.
Thank you, Mr. Chair. Just a quick question. Does the Maine Forest Service provide you, because it looks to me like you're in your company vehicle, do they provide you with any type of respiratory protection?
I know right now we are not issued respirators beyond what's been issued out for COVID-19. But we are in the process of getting respirators primarily for investigative purposes. They're not compatible really with the level of activity that's required and the level of exertion that's experienced during wildland fire suppression. But there is plan in place for us to be fitted with respirators going forward for some of the law enforcement investigations that we do around prohibited materials fires, structure fires, and that sort of thing.
So did they give you N95 masks for the COVID?
Yes.
All right. Thank you, Mr. Chair.
Are there any other questions for Mr. Barnum? Seeing none, thank you for being here, sir. We appreciate all your work, and we got to do something about those respirators, I'm thinking.
Thank you. Thank you for your time.
Thank you. I believe that we have nobody who is here to testify against the bill, and we have one person who is here to testify neither for nor against, and that is Mr. Hughes.
We do have one more person to testify in support of the bill. It's a new system, so a lot of people accidentally register as neither.
Gotcha. Okay, go ahead and bring them on in then, sir. Or,
So we have John Crowley with the Maine Forest Service.
all right, perfect.
Oh,
What happened?
yeah, he was here.
He's still in the. I don't. Oh, there he is.
All right, great. I am back. I got kicked off there for a minute. Good morning.
Good morning. We are all set whenever you are ready, sir.
Okay, great. Senator Rafferty, Representative Sylvester, and members of the committee. My name is John Crowley, and I'm the Chief Forest Ranger Pilot for the Forest Rangers of the Forest Protection Division of the Maine Forest Service. And I'm here today to testify in support of the LD 305. Ranger pilots fly helicopters to drop water on forest fires in support of the rangers who are fighting fire on the ground. These fires are often in the wildland-urban interface where the homes meet the forest. So the fuel of these fires is not just trees and brush. It's often includes structures such as homes and outbuildings, cars, farm equipment, tire piles, and trash dumps. There's no way to get at the fire with a helicopter to draw up water without flying through the smoke. And it's not unusual to smell the trash or the chemicals that you're flying through that are burning. Much like the rangers on the ground, we're breathing smoke for hours at a time and with no way to get out of it while still doing our jobs. In 2020, Ranger pilots assisted in suppressing 112 of the over 1,100 fires that Rangers responded to during the last season. And that just includes the suppression efforts. It's not unusual to be called back during mop-up to help clean up the fire, move people around, and pick up gear that was used on the fire to bring back to be repaired or cleaned. I would also state that Ranger pilots are dual rated in both helicopters and airplanes. And on any given day, we're not really sure what we'll be flying or what the mission will be. But we refuel our own aircraft, sometimes as often as 4 or 5 times a day, exposing ourselves to fuel vapors from both jet fuel and av gas, both of which have been linked to kidney cancer. And I'd also like to add that Forest Ranger pilots go through the same training as ground rangers and have the same law enforcement and fire authority as those ground rangers. Some of us were unit rangers on the ground before we were Forest Ranger pilots. So I'd like to ensure that though the Ranger pilots aren't listed in the title, they are Forest Rangers, and there should be no confusion that they're eligible for the benefits of this bill. So that may be something we want to discuss about whether or not we put that in the title. Often we just use the term Forest Rangers, but we have a forest fire prevention specialist who gets left out of a lot of stuff because his name isn't in it. And as we put that position in, we probably should have put the pilots in as well. I just want to make sure that it should cover all of the Rangers total. And in answer to one of the questions earlier, I, in 17 years, have not been tested for any type of cancer screening. And with that, I ask your support on voting yes for LD 305. And I'll answer any questions.
Thank you, Mr. Crowley. We appreciate your testimony today. looks like Representative Drinkwater has a question.
Thank you, Mr. Chair. Seeing as how I live right here in Milford, which is right next to Old Town, maybe I should go up in one of the helicopters and have a look for myself. Any thoughts on that, Mr. Crowley?
It's not unusual at all for people to swing by the hangar in Old Town, and I bet we could probably work something out.
Especially around moose season. Thank you, sir.
Thank you, Representative Drinkwater. It looks like Senator Miramont has a question.
Thank you, Mr. Chair. Just to make sure I'm not breaking protocol, I didn't plan to testify, but then I did. So is that right? Am I still on this one? Yes. So if you don't want me to ask a question, I won't, but it's a simple one.
Theoretically, Senator Miramont, what question would you have asked if you were allowed to testify?
That if departments have been through this before and know that it's quite a process to change a designation for, say, benefits or something, might they not classify all those who share duties as a forest ranger / pilot, forest ranger / something, to make sure that their folks who do the similar job in a different way are included, so that they don't have to come to the legislature to make small changes? Just a thought, not necessarily a question of anyone. Thank you.
Thank you, Senator Miramont. You are not allowed to ask that question, but a question just occurred to me that perhaps for the work session, we could look at those classifications to see whether or not they are included in terms of the way those jobs are classified with the state, and then so that we can make an adjustment if we need to within the with an amendment on that. And Mr. Crowley, it sounded like you thought that they were listed separately with different job duties, or they were listed as one category with a long list of positions?
Well, we're going to ask something for testimony that we're giving on Wednesday in front of your committee to change the title again, because, you know, often it's a modification from another bill where just forest rangers were used. But in that particular bill, when you compare it to the other agencies, they said all law enforcement agents, officers in the Inland Fisheries and Wildlife Department. So that covered it. In this particular case, because we're just not sure how to make sure that everybody is covered. If it said something along the lines of all forest ranger classifications, that would cover everybody.
All right, thank you, Mr. Crowley. And Steve, for the work session, if we could try to make sure we're as all encompassing as possible so that we have an option to do that, that would be fantastic. Are there any other questions for Mr. Crowley? Seeing none. Thank you, sir. Appreciate your testimony today.
Great. Thank you. Have a great day.
Alyssa, is there anyone else left to testify on 305?
We have no more proponents, no opponents, and one neither for nor against. And that would be Mr. Hughes.
Perfect. I see Mr. Hughes coming in as we speak.
Can you hear
Welcome,
me?
Mr. Hughes.
Good morning. Can you hear me?
Yes, we can. You go ahead whenever you're ready.
Good afternoon. Good morning, Senator Rafferty, Representative Sylvester, and members of the Labor and Housing Committee. My name is Richard Hughes. I am General Counsel to the Maine Workers' Compensation Board. I'm here to testify neither for nor against LD 305, but will attempt to answer any questions you may have about the bill. If during the coming weeks you should have questions or should need information about LD 305, please forward your inquiry to the Workers' Compensation Board. We will try to locate information you seek and transmit it to you as quickly as we can. Thank you.
Thank you, Mr. Hughes. Are there any questions for Mr. Hughes? I see Representative Drinkwater and Representative Bradstreet.
Thank you, Mr. Chair. And thank you for coming forward. I guess My question is about workman's comp. It says in 2009, a change was made to the workman's comp, and maybe he can't answer it. Maybe this is something for the work session, but are we seeing a mission creep when it comes to presumptive classification?
I can't answer that, actually, but I'd be happy to. Perhaps some more information when you say mission creep. You mean, are we adding more and more people to the presumption, to the list of those who would benefit from the presumption?
Yes.
I guess it's simply a matter of looking back at the statute, sir, and ascertaining whether more have been added to the presumptive list. We could go back and take a look and let you know.
Thank you. Maybe that's something we could get for the work session. Thank you, Mr. Chair.
Thank you, Representative. Representative Bradstreet.
Thank you, Mr. Chair, and thank you, Mr. Hughes, for being here. My question, actually, my request was also that maybe we have a list of those who are considered under the presumption category for the work session. And I guess just for clarification, the employer we're talking about here is always the state of Maine. Is that not correct?
That's my understanding.
And okay, thank you. And I also would like to know if there's any data we can get showing the incidence of cancer of firefighters compared to those maybe who would be covered under this bill. Anything we could get in that regard would be very helpful.
We'll look for that.
Thank you. Appreciate it.
Yes, sir.
Representative Geer.
Thank you, Mr. Chair. I am curious, Mr. Hughes, regarding the process that is followed when a workers' compensation claim comes in under one of these rebuttable presumption categories. How does that work once you receive the claim?
Ultimately, the claim can be, well, first, it goes to a troubleshooter, and someone in the troubleshooter's office contacts the employer and the insurer and presents the claim. If the claim isn't paid or resolved at that time, it's then referred to the advocate's office at the Workers' Compensation Board for legal representation. At that time, it's scheduled for mediation, which of course brings the parties together, and they try to resolve it at that point, find out facts, and see if the insurer will voluntarily pay at that point. And if it's not resolved at that level, then Representative Geer, it goes to private counsel or stays with the Workers' Compensation Board's advocate division, which is often the case. And then it's put into formal litigation, and it would go to hearing and ultimately be decided by an administrative law judge.
Great, thank you. Can I have a follow-up, Mr. Chair?
Yes, you may.
Great, and then specifically related to the rebuttable presumption categories. So I'm just theorizing and making sure I understand. Someone would come with a diagnosis of cancer. They are a firefighter in their job, and the presumption is that that cancer in the categories was caused by their firefighting experience. Does that fit into the process that you described as then the someone would need to come and say, I'm rebutting that. It could be, it's from something else. I just want to make sure I understand how that process works.
Sure. The rebuttable presumption would work basically like this, and I could take a quote from a recent case if that's helpful. When a rebuttable presumption applies, the employer bears the burden to prove the non-existence of the presumed fact on a more probable than not basis. And so the employer's burden would be to show that the particular cancer did not arise out of and in the course of the firefighter's job.
Great, thank you.
So for example, Mr. Hughes, this is Representative Sylvester again. The employer could come in and offer evidence such as that the ranger was a 3-pack-a-day smoker and had worked with asbestos for 20 years before becoming a, those sorts of issues would be the evidence that would be put forward to rebut the presumption. Is that reasonable?
Yes, it is, actually, yes. I would expect that would be, those would be among the facts advanced to rebut the presumption.
Okay, thank you very much.
Yeah.
Representative Pepworth.
Thank you, Mr. Chair. Thank you, Mr. Hughes. My question is about cancer screenings, which we understand happen in or are required in some situations, but I'm curious how they fit into this bill. And you may not be the person to ask this question of, but here I am asking it.
In order to be entitled, I'm reading from the statute, basically, and that's section 328-B, section 3. In order to be entitled to the presumption in subsection 2, during the time of employment as a firefighter, the firefighter must have undergone a standard medically acceptable test for evidence of the cancer for which the presumption is sought. And the test must have failed to indicate the presence or condition of the cancer, if that's helpful.
Mr. Hughes, I have another question, Chair's prerogative. I'll take a second question. Does it seem to you, this comes up all the time. We read this particular statute, and I think that what is always unclear is on these professions that have presumptions, particularly for cancer, it requires that there was a prior test, negative test, but there doesn't seem to be any policy to require such a test. And so I'm wondering if you see that as a contradiction in terms of trying to add more folks to presumptions, but not taking care of that root cause, which is knowing that we had a negative test to begin with, because it would seem to throw the burden back onto the employee if they had not been provided such a test by their employer as part of their health screening.
That's a good point. And one way to solve that might be to mandate that notice be given. Some of the witnesses have testified that have testified to the existence of some kind of policy. And since the Workers' Compensation Act doesn't mandate it, it would be up to the insurance carrier or the employer, or well, actually either one, to promulgate some kind of a policy on that.
Okay, thank you. I just wanted to make sure we hear it all the time. I just wanted to sort of, you seem to be the right person to ask that of, since you are the attorney of record.
Yes, sir.
Oh, Representative Drinkwater, I think you have another question.
Yes, thank you. Obviously, talking about cancer, getting services to treat the cancer is paramount. So under presumptive, and I don't know if you have records of to see how fast it works through the system versus presumptive or non-presumptive. Do we keep any data such as that? Is it faster to get through the process under presumptive?
Not necessarily. Any party has the right to litigate a claim and see how the proof ends up being presented and how the administrative law judge responds to the evidence that's submitted at hearing. So it's not really at the gate, if you will, sir, that the claim has to be accepted or not. The presumption is it's an evidentiary issue taken up later in the litigation process. It might be an incentive to pay a claim early, possibly if there's no countervailing evidence, but it takes time to develop the evidence. So the presumption comes into play at the hearing as an evidentiary matter.
So one would assume on the presumption that it takes a long time to work its way through the process in order to be verified as a claim.
I don't really know. I mean, I'd have to, maybe I don't understand. I don't know that the existence of a presumption expedites the processing of the claim, if that helps.
That does help, because that's what I was searching for. Is it faster to be presumptive or is it faster to be non-presumptive? And in my experience as a small employer with auto mechanics who were not presumptive, it still takes a long time to work through the system to get it so they will pay. Thank you.
Representative Prescott.
Well, thank you. If we implement this to the people that are already employed, there's still going to be a gray area, when they got cancer. So this is just kind of food for thought, or maybe I didn't catch it. For new hires, is there any screening for this? Because as we all know, you can get cancer in many places. They got over-the-counter medicines that are on the news right now, GMO foods, and the list goes on. So just food for thought about pre-screening new hires at this point.
If a annual physical occurs and history regarding cancer is taken and recorded, history of the firefighter's own cancer, if there was any, or in the absence of it would be relevant, specific examinations to see if the cancer is detected. And that all could be in an annual physical or in a test that the firefighter could undergo. As long as the firefighter undergoes that test and it's negative, then from my interpretation of statute is that the medical examination requirement is satisfied.
Okay, thank you.
Thank you. Are there any other questions for Mr. Hughes? Seeing none. Alyssa, do we have anyone else to testify?
No, we do not.
All right. Seeing no one else to testify, we shall close the hearing on LD 305. And we'll see you, Senator Sarah White. Thank you for being here today.
Thanks a lot.
All right. Be well. And we shall open the hearing on LD 358, an act to protect workers from unsafe working conditions with regard to indoor temperatures. And Representative Bruce White of Waterville is the sponsor.
Hello.
Hello, Representative White. How are you today?
Good. All right. I'm waiting to show up, I think. There it is. Okay.
There you are.
All right. I'm on. Okay. Just wanted to make sure. Thank you.
Perfect. Whenever you're ready, sir.
Thanks. And I will say thank you to your committee clerk, Alyssa. She's been very helpful. This is very a change for all of us. And she has walked me through some of the process. My first time presenting, for a public hearing. So.
Well, we welcome you today, sir. And certainly this committee is blessed to have Alyssa and Steve holding our hands much of the time. But whenever you're ready, Representative.
Well, thank you. Because I would say, who would have ever thought that years down the road, they'd still be saying, "Can you hear me now?" We don't remember when that came out. Anyway, thank you, Senator Rafferty, Representative Sylvester, and members of the Labor and Housing Committee. My name is Bruce White, and I serve Waterville's District 109 in the main house. I am here today to present LD 358, an act to protect workers from unsafe working conditions with regard to indoor temperatures. Currently, there are no minimum and maximum temperatures required for indoor places of work. This bill would require the Department of Labor, Board of Occupational Safety and Health to establish these requirements. The original complaint, which generated my interest in submitting this bill, came from an employee at a retail establishment that had a furnace issue, and the employee was forced to stay in the building without any heat. There do not seem to be any clear guidelines regarding unhealthy situations, as I have mentioned. I would ask that the DOL establish and set guidelines around temperatures in indoor places of employment. I understand there could be unintended consequences, and my hope is that those can be addressed by your committee. Employees deserve to work in comfortable temperatures, and I hope the committee will vote ought to pass on LD 358. I'd be happy to try to answer any questions now or at the work session when it is scheduled. And thank you for your time.
Thank you, Representative White. Are there any questions for the good representative? I had one, sir. So what you're seeking to do is to have the DOL set guidelines, just sort of suggestions, because as we've heard on a previous bill, the private sector comes under OSHA, whereas public sector buildings, such as the State House, come under OSHA. And I'm wondering, are you looking to set guidelines across just as recommendations, or are you looking to set standards for public buildings and guidelines for the private sector?
This would be guidelines more for the private sector. Although I do think that if there, depending what there is control over, I mean, some of the public sector would have, could have some impact, but mainly for the private sector.
Yep. So you're just basically asking them to review it then?
That's correct. Yeah.
Okay. All right. Thank you. I appreciate that. Looks like Representative Gear has a question.
Thank you, Mr. Chair. My question is whether if this is for the private sector would fall under federal OSHA regulations. Am I correct in understanding that there is not currently any regulation in place about workplace temperature?
That's where there seems to be confusion on this, so I'm not clear on it. Would hope that that would come out maybe if there is, maybe later in testimony or at the work session.
Okay, thank you, Representative.
Representative Prescott.
Well, thank you. Is it the intent of this bill for indoor temperatures to basically look at places that have climate controlled environments? Because when we say inside, we have warehousing, which is actually inside, but the doors are open all day because they're loading. Is there any more specific information on exactly what we're looking at here?
Yeah, great point. I mean, I understand that, some people have to go into a cooler during the day to get beverages out, for instance, or meat from, it isn't intended for that. It's to me, it's what's the normal climate in your work environment. And if there's some extremes, then that should be addressed, at least some guidelines.
Are there any other questions for the representative? Seeing none, thank you for bringing us this bill today, Representative. And
looks like there was one.
Oh, did you have another question, Ms. Representative Drinkwater? I thought that was a carryover. You are muted, sir.
No, it's not a carryover, Mr.
Oh,
Chair.
okay, great. Representative.
Representative White, interestingly, of all the public hearings we've had this morning, yours has generated the most responses from different organizations. I'd like to give you an opportunity to talk about what I'm hearing is about government overreach and the fact that, they're trying even to dictate temperatures in a building. Would you have any comment on that at all?
Well, I would just say that, I mean, a person should be able to have an expectation of being in a safe, healthy climate. And I don't think it's overreach. And if a person, again, it's extreme conditions we're talking about. In fact, I work in a paper mill, so I know what it's like to work in, you know, uncomfortable conditions. But if somebody goes in and is, you know, used to a certain climate, and all of a sudden it's, you know, 40 degrees, and that person should have some leeway on, you know, leaving that site or having that condition addressed immediately. So I don't think it's an overreach.
Thank you.
And as I will say, as I mentioned in my testimony, I understand there sometimes, you know, unintended consequences, but I don't think that's a reason to avoid addressing this and looking at some guidelines.
Representative Rader.
Thank you so much. Thank you so much, Representative White. I have a question regarding mitigation efforts by employers. So is that addressed, and how would it be addressed? So for example, if there was a minimum temperature that was not yet met by an employer, but they provided protective gear and or some sort of space heater to try to mitigate that effort, is that something that will be included in this?
I think that would make sense. In fact, I mean, if I went to work in a certain place and I was expecting a certain climate during the day and I didn't have the necessary gear, and then they had some extreme temperature one way or another, I think the employer, you know, to provide something would make sense.
And Representative, just to follow up on Representative Rader's question, I mean, you're not purporting to write a bill that would provide what all these extremes are and who should be provided gear and where. You're just asking the DOL to look at it and come up with guidelines for whatever situations it seems might come up. And often we set together working groups to sort of look at these things. Would you be open to a working group to sort of interested parties in order to try to establish some of these things?
Yes, I certainly would be. And you're correct. We're just looking at guidelines, not to overcomplicate things either.
Perfect. Yeah. Then that, you know, Steve, I'd like to just sort of note that for the work session, that might be one avenue that the department could think about if this bill is successful, is to put together a working group of interested parties. Are there any other questions for Representative White? Seeing none, thank you, sir. Appreciate you bringing this bill to us, and safe travels home.
You bet. Thank you. I was disappointed, you know, not to have to travel there and wait a couple hours in the hallway or something. So.
Well, you're welcome. Next bill you bring to us, you're welcome to just come and wait.
Thanks. Have a great day, everybody.
All right. Be well, sir. Before we move on, Senator Miramont is a co-sponsor who is going to testify. But before we move on, I noticed that Senator Guerin and Representative Cuddy have joined us. Senator Guerin, did you want to introduce yourself?
Certainly. Thank you for the opportunity. I have been out at another hearing today in the Natural Resources Committee. I am Senator Stacey Guerin, representing Southern Penobscot County.
Thank you, Senator, and welcome back. Representative Cuddy.
Good morning. My name is Scott Cuddy. I represent House District 98, which is Winterport, Frankfort, Searsport, and Swanville.
Excellent. Thank you, sir. And now we'll welcome back up to the podium Senator Miramont, who is a co-sponsor on this bill.
Thank you, Mr. Chair. And good morning to you and Senator Rafferty and the committee. I already introduced myself. This bill requires the Department of Labor establish temperatures that can be expected during the performance of a worker's duties. This bill requires appropriate temperature ranges to be set for those duties based on the situation. A school or office would have a range that is normal and reasonable, as well as appropriate range if the job involves working in a freezer or on a paper machine in a mill. We are attempting to give employers and employees a guide to expectations. It will establish the inappropriateness of a business owner trying to save money on fuel by lowering or raising the temperature of a workspace by a certain number of degrees when the employees would have no recourse except to leave their job. It would seem to be common sense and that a bill such as this is unnecessary, but I've seen time and time again that common sense is not always at the forefront of our society. We also try to bring people together, often bringing concept bills to a committee to get the folks who work on, say, a labor issue every day to help draft the best legislation. We're trying not to do that this time. So we're asking the department who works with these issues to do it, which is another way to get some thoughtful consideration. And regarding OSHA or not, when there are different groups that oversee workplace issues, if there's an established guideline that, say, a legislature has put in place for part of the issue, then I believe that other groups, other government agencies such as OSHA would look at those when considering the other part of an issue in a state. That's not an absolute. It just seems that there is a little look across when a group has taken the time to go through the research and go all the way through creating a bill that gives guidelines. So thank you for your consideration. I'll try to answer any questions.
Thank you, Senator. Are there any questions for the senator? Seeing none, good sir. We appreciate your testimony today. Alyssa, who do we have up next?
Next, we have Jeff McCabe.
The Honorable Mr. McCabe is going to get frequent flyer miles this morning.
Good morning, Chair Rafferty, Chair Sylvester, members of the Committee on Labor and Housing. My name is Jeff McCabe, and I typically avoid testifying 3 or more times before a committee in the same day, but all these bills came up and I just wanted to flag for you all. I'm still the Director of Politics and Legislation for Maine Service Employees Association. And we are here today in support of LD 358. And we believe very strongly in the stakeholder process when it comes to issues like this, as well as it relates to setting guidelines. There's been great conversation this morning around this, and I will say that this is more of an issue than you may realize in public buildings. And for that reason, we just wanted to come today, be a resource, get on the record in support of this bill, and actually think that this could lead to a productive conversation, as well as possibly not addressing this work site by work site as it relates to the public sector. This is a bill that comes up this is an issue that comes up every winter and every summer for us, and it can sometimes be more complicated than it should to address issues of a minimum and maximum indoor temperature in different work sites around the state. So really just looking to be a resource to both the committee as well as DOL as this moves forward.
Thank you, Mr. McCabe. Are there any questions for Mr. McCabe? Representative Bradstreet.
Thank you, Mr. Chair, and thank you, Mr. McCabe. You mentioned that it's been a matter of discussion for quite a while now. You talking about within the legislative realm as far as law, rulemaking or lawmaking, or do you have more in mind about negotiations between the employer and the employees?
Thank you, Representative Bradstreet. I should have prefaced this with, I also had an opportunity to talk with the bill sponsor to understand sort of where he was coming from in regards to retail space. But I think for us, if this picks up public sector, then we are interested because of our representational role. And what we have seen is at times ongoing grievances and other issues that have come up in both publicly owned, but also in spaces that are often rented by the state. And a great deal of money is spent on those locations. In inadequate heating or inadequate cooling can lead to productivity issues, as well as, at times buildings needing to be closed. in a very disruptive process. I think there's several locations in Augusta that have been sort of chronic when it comes to the issue of heat. And then there's also some others that I'm aware of elsewhere that have been issues around cooling. And these often, take a great deal of time to sort of remedy, where I believe that if there was clear guidelines provided for those work sites, that would probably be a much more appropriate way of dealing with this, versus that grievance process.
Representative Drinkwater.
Thank you, Mr. Chair. Thank you, Mr. McCabe. You brought up an interesting point. A lot of buildings are rented by the state of Maine. I'm thinking in particular Department of Health and Human Services. They rent a lot of buildings from the private sector. So are you saying that even in a hot summer day, if a certain building does not have air conditioning, that could be a complaint? That it got too hot in this building?
Absolutely, Representative. This is absolutely an issue.
And that could be a negotiated item, and maybe that would force the state to say, hey, we're not going to renew our contract, we're moving somewhere else, which is very disruptive. So thank you for bringing up that point. That was an interesting point.
Absolutely. And I think, if you look at, there was a situation where a building in Biddeford had, chronic issues. Those were more associated with plumbing, mold issues, some air quality issues. But DHHS just moved out of that space and sort of abruptly closed that office. So I think that, often creating these types of standards and guidelines is probably a more beneficial and proactive way to go about it. I'm not necessarily saying I know what that temperature range should be, but if you think, you brought up the issue of DHHS buildings, those are often buildings that don't have the ability to even open a window. Those are often spaces that are windowless, and to think of what that would be like, and also the issue too is you could think about this ongoing too. You might have a situation where over a course of multiple days in the summer, that air condition isn't functioning, or, adequate air exchange isn't available. So definitely some health and safety concerns there.
Representative Bradstreet, another question?
Yes, thank you. I know people who work in a public building, not necessarily from the state, but for some people, the temperature is too hot, and at the same place for other people, it's too cool. So how would we ever remedy that disagreement and what goes on?
I think that's a great question. And I think that's yet another reason to have some sort of guidelines that are provided. I think you're looking at sort of a temperature range, and I think we have those same disagreements within our own households as well, Representative Bradstreet. And I think that as we modernize buildings and things, to set them in sort of a temperature range is probably most appropriate. The issue in regards to the new DHHS building, or if one was to go to the new main PERS building, I believe those are all buildings that are sort of the most modern as it relates to heating and cooling. And in those buildings are kept within a very specific range. I know it's going to get more challenging as you look at sort of, the overall portfolio of public buildings and trying to figure out what that temperature range is. But I think realistically, it's that range. There is always going to be some folks that run a little hot and some folks that run a little cold. And so I think that having some sort of guidelines and standards. I also did appreciate the conversations in reference to other locations as well. We also have public spaces that are very much associated with the elements. I think of the Fleet Garage, where all of the work is done on DOT vehicles, fabrication of components to the ferry service. That's a very large warehouse type space where frequently the doors are left open. So, that is very much, built into sort of the equipment that's provided to those individuals. They're provided uniforms, but then beyond that, they're also provided jackets and things of that nature. So I think from our perspective, it's having some sort of temperature range guidelines would be extremely helpful. It would be something that the employer the employees would have, as well as would be provided to whoever it is in charge of maintaining that space, whether it's BGS for the state or whether it's a private landlord.
Senator, thank you, Representative Bradstreet. Senator Rafferty.
Thank you, Representative Sylvester. Jeff, as I'm listening, we've kind of gone back and forth between, initially I thought this was for, oh, I'm sorry, any work area. And it's, so let me, that's perfect timing, isn't it? Sorry about that. So,
Senator, I believe your extended warranty is in danger of lapsing.
It probably is. So I'm hearing it kind of goes back and forth. I thought this would for any work area, but you've several times mentioned public work areas. And so I know myself, I received a call from a guy that's in the restaurant industry over the weekend, and he's like fearful of what's going to happen in his kitchen with his workforce, perhaps on a summer day. So I'm trying to kind of narrow it down a little bit if you can for me.
Absolutely. Absolutely. And I think that's where, the bill sponsor had referenced sort of that stakeholder group as well. And I think that those types of things and somebody like Director Rowland and others, spend some time thinking about how this would, affect others. I was sitting here writing down the places I've been in things locally to me. I believe it was, I can't remember if it was Representative Prescott, raised the issue of warehouse space. And I think of the folks that work over at the ice cream factory here in town. I would name it, but I don't want to necessarily name it. And when you go to pick something up there, they show up and they're wearing their refrigerator wear. And that's literally what it's called. And it's a warm jumpsuit. So my interest, Senator, is really sort of that public sector piece in just seeing if this would pick that up. But I think that, there is worthy discussion. I from time to time, work in a kitchen space. I do some work that's outside, and all of those things would, I don't want to necessarily call it an exemption, but there would need to be some sort of reference to those types of work environments as well.
Thank you.
Thank you.
Representative Cuddy.
Thank you, Mr. Chair. Thank you, Mr. McCabe, for your testimony here today. And as I read the bill, it talks about safe and healthful conditions. So we're not discussing issues of comfort, it's safety. Am I getting that correct in your estimation?
I believe that's, correct. And I think of this in a situation of like, the heat goes out in a building and it's looking at day 2, and is that maybe day 1 people were sent home, but what's the second day look like? You're going to bring people back in when the building is, 40 degrees or, but also sometimes I think you see spaces that might not adequately be set up, specific to the sort of retail situation. Is there a situation where somebody is working in a space that has no heat? And then it's a situation where somebody is working in space where it's in the 20s, and that might not be appropriate. Or if it is, maybe people need to be prepared for that and provided the appropriate gear.
Thank you.
Seeing no other questions, I'm gonna ask a quick one. I like to try to be illustrative on these things. As we were talking, I was reminded of a story from a past life of mine, working with LBHS workers up in Holton. And the heat in this particular rented building was pulled in from the top, from the open air, and heated on the way down. And you might be surprised to find out that it's cold in Holton in the winter. And so the air, as it was pulled in, it would take a couple hours to actually warm up the building. But then what would happen, it would be 75 above the desks and 45 below the desks, because the air never quite circulated under the desk systems that they had there. And there was a huge dispute about that, about what was healthy, what was safe, and there were no guidelines. Is this the sort of thing that you're trying to discuss, where something is long-term, unhealthful, and there's a dispute, or there's some sort of question about what the correct temperature should be.
I would answer in the affirmative to that, Representative. That's how I see this. And if not, you understand sort of the grievance process probably better than a lot. And if we could remedy things ahead of time, it might save a lot of time and money on all parties if there was clear guidance provided.
Thank you very much. Are there any other questions for Mr. McCabe? All right. Thank you for being here today, sir.
Thank you.
Appreciate you. All right. We have a long list of folks to testify. Alyssa, who do we have? Who are the next three?
So that was our only proponent. So moving on to opponents, we have Allison Susi, followed by Bruce Gurnedy.
And while Ms. Susi is coming in, I'll just remind folks that if they set their view to gallery, that they will be able to see all of the committee. And why that might be important is that I'll be holding up my little phone here with the timer on it. Everybody's going to have 3 minutes. At 30 seconds, I'll pop it up at the beginning. At 30 seconds, I'll pop it up again so that you can see the sort of the rundown. And then at the end of the 3 minutes, I'll ask you if you could summarize your thoughts. So thank you for being here, Ms. Susi. We appreciate you. And whenever you're ready to begin.
Thank you, Representative Sylvester and Senator Rafferty and members of the Labor and Housing Committee. My name is Allison Susi. I'm the Director of Government Affairs for the Maine Tourism Association, and MTA is a nonprofit statewide membership association that represents every type of tourism business, such as lodging, restaurants, retail, amusements, outdoor recreation, camps and campgrounds, historical, cultural attractions, and guides and tours. And I'm testifying in opposition to LD 358. As you've heard, even from the sponsor, there are some unintended, I think, consequences. So we definitely support the good intentions of the bill's sponsor to keep employees from spending their entire workday in extreme or unsafe, unhealthy temperatures when that could reasonably be avoided. But the bill is drafted far too broadly and has a number of issues. It reads to me with the Title 26 definition of workplace, which is used in this bill, that every shed, garage, barn, storage building, and warehouse would have to be insulated and have some type of HVAC system to maintain temperatures even within a certain range. And that would be tremendously expensive and unreasonable for buildings where employees either don't work in them at all or in and out for short periods of time. For example, to get out a lawnmower, store kayaks, or to unload boxes of t-shirts and then return to a temperature controlled gift shop. Also, there are a number of indoor workplaces that we represent that are a little bit non-traditional, such as boats, cabins, yurts, historic buildings like forts, where the authentic experience does not need or would not be expected to have a regulated temperature for those experiences. And obviously employees work in those areas as well as visitors visiting them. Again, as some of the earlier folks had mentioned, it appears to cover even buildings like greenhouses or walk-in freezers where they need to be at extreme temperatures, and not to I know the good folks at the Board of Occupational Safety and Health would recognize this, but still, if they're being given directive, it would need to be clarified. So for these reasons, we see it as problematic. Thank you.
Thank you, Ms. Susi. Are there any questions from the committee? Representative Drinkwater.
Thank you, Mr. Chair. Maine tourism. We love it. This state really depends a lot on it. So giving you a scenario, a lot of people like to cross-country ski, and there's a lot of resorts that you cross-country ski to and spend the night in remote cabins. Do you foresee that perhaps that could be a problem area? Because when you get to the cabin, you have to build your own fire to warm up the cabin.
Well, it would depend on the situation. I mean, certainly that could be. You would have workers who presumably go to these places to check them out, clean them up in between customers and so forth. So if that's the case, it would be considered a workplace under this bill as I read it, and would have to be. And again, you're right, as part of the cabin experience, you expect it to be unheated and you just have a wood stove and so forth. So it seems like it would be swept in under this bill as written.
Thank you.
Are there any other questions? Ms. Susie, it seems that the sponsor was really looking to sort of put together a working group under DOL to kind of come up with the rules that made sense and the ones that don't make sense. If that were the case, would you be willing to serve on such a group?
Absolutely. Yeah,
Right,
I really appreciate the sponsor's intent to clarify what he was trying to get at. And I did have a discussion with him before this hearing. But as I say, I'm just presenting testimony on what's written and hopefully it can drive us towards a better solution.
Appreciate that. Thank you.
Thank
Are there
you.
any other questions for Ms. Susie? Seeing none, thank you for testifying today. I believe next is Bruce Garrity. And that'll be followed by Dana Doran.
Am I there, Representative?
I see you loud and clear, Mr. Garrity. How are you today?
You see me loud and clear. That helps.
That's Zoom technology, my friend.
Senator Rafferty, Representative Sylvester, and members of the committee. My name is Bruce Garrity. I'm an attorney with Pretty Flaherty, and I'm here on behalf of my client, the Maine Auto Dealers Association. The association is comprised of all the new car and truck dealers in the state of Maine. Before I comment directly on the auto dealer situation, I'd like to make a couple points in relation to OSHA. First, OSHA refers to this issue as the temperature wars, and has sent out the following quote: "The Occupational Safety and Health Administration recognizes that a comfortable temperature differs from person to person. Therefore, OSHA does not regulate workplace temperature, but OSHA does recommend that employers keep the thermostat set between 68 and 78 degrees Fahrenheit. OSHA will step in if the temperatures are so severe that employees are risking their health." So that's what OSHA has had to say on this issue. From an auto dealer perspective, and I'm really focusing on what they call the back end, which is the service area, it's a very different situation than many other places. In the first place, there are huge doors that are constantly opening and closing so that cars can come in and out. That makes direct temperature control a real challenge if it's a really cold day or if it's a really hot day. Dealerships do have fans, they do have air conditioning units, they do have fans that are part of heat pump systems, but the reality is the temperature varies as cars go in and out. The second thing that happens is those doors have to be open from time to time because there's so many fumes, carbon monoxide, gas vapors, and the like in that kind of workplace that venting it is really critical to the health of everybody who is working there. The third point I would make is that this isn't a situation where you can control the temperature for one employee differently than another. These are huge open workspaces. Techs are next to each other. They all have their own service bays, their own tools and the like, but there's no barriers between them, and there's no way to control the environment for one or the other. So respectfully, we don't think this kind of situation in any way fits the kind of concern that has been addressed by the sponsor. It's just very different. In the event that the committee decides that it wants to pursue this legislation, we would ask that that auto dealerships be exempted out of it, because I don't think whether you're the Department of Labor or the legislature directly that you can effectively really control this kind of situation. I will say that dealers generally do their best to keep the temperatures in a comfortable level. I don't think you see too many extremes at all. And of course, whether you call it from a business or a health perspective, the last thing dealers want is to have customers concerned or unproductive technicians, and obviously temperature is a part of that.
Thank you, Mr. Garrity. That is the end of your 3 minutes. I forgot to hold it up at the 30 seconds there. My dog
I actually was keeping an eye on you, Representative.
I know, I saw it, and then I was keeping an eye on my dog, who was trying to chew on the side of the wall. And
I can. Is it a lab? They have that.
We do not know what this dog is. It's a rescue.
Well, let me close by saying this. I had one other quick point to make, Representative, which is that you're also dealing with engines and parts that are themselves extremely hot. And you got to be careful how you dress. You got to be careful how you act around a hot engine. And that obviously affects ambient air temperature as well, and dealers keep that in mind. And with that, I appreciate the opportunity to have testified. I'd be happy to answer any questions the committee might have.
Thank you, Mr. Garrity. I see Representative Cuddy and Senator Rafferty. Representative Cuddy.
Thank you very much, Mr. Chair. Thank you very much for being here, Mr. Garrett. It's good to see you again, even if it is just virtually.
Same thing here.
Your testimony addressed comfort, and as I read the legislation, it is talking about a safe and healthful condition. So why the focus on comfort?
Well, I think in part, that was a point made by OSHA, so I picked up that point from OSHA. I recognize that this does deal with health, and it does deal with safety. And I think all the points I made, Representative, apply in that context as well. At least in an auto dealer context, if we want to only talk about extremes, I don't think you have those extremes, which I think is another reason why the committee should closely look at whether this legislation should be pursued, and if it should be pursued, for what kinds of facilities. It's one thing to say that if you work in an office space and the heat goes out and the temperature drops to 40 degrees, that you should deal with that. I don't think anyone would suggest otherwise. I think it's another thing to try and talk about a temperature that is variable depending on what is going on, but generally efforts are made to keep it in a moderate range. I think they're very different situations. And my sense, especially from the sponsor's testimony, Representative, where he was concerned about someone working without a furnace, his concerns were addressed more to the former.
Thank you.
Senator Rafferty.
Thank you. I think in general, Mr. Garrity covered them with Representative Cuddy's questions. I mean, it appears your description were temporary situations when you're in a garage, whether it's created an instant hot or an instant cold situation. But I think that the bill appears, from my view, to be targeted at your work day. So if I were in an environment where my work day was in an excessive cold or an excessive hot area, then my work day, the employer would probably need to adjust that day. Am I misreading this?
Well, let me respond a couple of ways, Senator, and I appreciate your question. At least in an auto dealership, it's not a temporary or momentary situation. But take an average back-end operation for a good-sized dealership, you're probably talking between 6 and 10 really huge doors, maybe twice the size of our normal garage door. They're constantly opening and closing. It's not a once in a great while thing, whether a car's coming in or out, whether you're venting or for whatever other reason. So I think it's a reality of that kind of workplace. And that is what dealers try to address. That's why if you go in one of those spaces, you'll see these huge fans around the facility, either driving heat from heat pumps or driving cold air to keep the area more comfortable. I think that responds to that question. On a broader basis, I think that if you are trying to regulate a general workplace environment, this is the kind of situation that should be exempt from that, because there's no way around having the doors open and close. There's no way around these constant temperature changes. Although as a rule, I think it's pretty fair to say the temperature falls into a moderate range.
Thank you.
Are there any other questions for Mr. Garrity? Representative Drinkwater.
Thank you, Mr. Chair. Did I hear you say that OSHA already covers this topic?
OSHA has discussed the topic, Representative, and has chosen specifically not to put standards in place. And I found it interesting that they referred to it as, quote, temperature wars, and recognize that different people are comfortable at different temperatures. But I think even the OSHA regulations were geared towards more of an office or a building environment, not so much an environment like that presented in the back end of an auto dealership.
Certainly, and I had the privilege of going through the Hood processing plant in Portland a few years ago. And in that, they have to have a certain temperature because of the, the milk and the ice cream, et cetera. So I could see where that would be very problematic for them also. Thank you very much.
Yeah, you're welcome, Representative.
Are there any other questions for Mr. Garrity? Seeing none, thank you, sir.
Thank you.
Oh, and Mr. Garrity, before you go, if the Department of Labor decides to put together a work group, I'm assuming you'd want to be a part of that to discuss your questions.
Oh, very much so, Representative. Thank you.
Thank you. All right. Appreciate you being here today. Next is Dana Doran. And Alyssa, do we know who's next after Dana?
According to our list, it would be Michelle Pelletier, though I don't see her. So it would be Stephen Bailey.
Okay, thank you.
Mm-hmm.
Good afternoon, Senator Rafferty, Representative Sylvester. I hope you can hear me all right. Hear me and see me?
You are perfect, Dana. Whenever you're ready to
Fantastic.
go.
Thank you very much. Good to see all of you and all the members of the Joint Standing Committee on Labor and Housing. My name is Dana Duran, and I'm Executive Director of the Professional Logging Contractors of Maine, a trade association that represents loggers and truckers in the state. Logging is responsible for 3,900 jobs and the creation of an additional 5,400 indirect jobs and about $620 million to the Maine economy. I've provided written testimony, so you should have that at your disposal. I will try to summarize because I know you've been at it since about 10, and it sounds like there's quite a few more to go. So we are, while we certainly understand and appreciate the sponsor's intent with this legislation, and I have reached out to him over the weekend to let him know where we stand. We are in opposition to LD 358 on two specific purposes. So I will start with the first one and then move to the second. So the first reason we are in opposition is that there is no general definition of what an indoor place of employment is, and I want to expand upon that. So in logging, our industry has many indoor spaces. We have operators who work in harvesting machines. They travel in pickup trucks. They work in garages. They may drive a tractor trailer. They may move back and forth between all of those places. And they work in very harsh outdoor environments year round. Weather and temperature change constantly. And what is deemed acceptable in terms of temperature is very subjective, first of all, but we also don't know what an indoor space is. So I did want to bring that to your attention that at this point, this legislation doesn't really define what is an indoor space. Secondly, as Mr. Garrity pointed out, and I'm going to refer specifically to OSHA on cold climates and cold environments, but their interpretation is the same on warm environments. OSHA does not have a specific standard that covers working in cold environments under the OSHA Act of 1970. Employers already have a duty to protect workers from recognized hazards, including cold stress hazards that are causing or likely to cause death or serious physical harm in the workplace. If Maine were to enact this legislation, it would go above and beyond what OSHA already regulates. Additionally, the definition of what constitutes indoor constitutes indoor temperatures at workplaces to ensure safe and healthful conditions is potentially very subjective and almost impossible to maintain from one employee to another, especially in our industry where employees operate in socially distanced cabs almost exclusively by themselves. So again, I'd have you refer to the rest of my testimony for background on our industry, but for those two reasons, we would urge the committee to vote ought not to pass on this legislation. So thank you, and I'm going to yield back the balance of my time.
We will send that time to you in the mail, Mr. Duran.
Appreciate it.
Are there any questions for Mr. Duran? Seeing none. Thank you, sir.
Thank you.
And next, I believe we have Stephen Bailey. And that will be followed by Curtis Picard. Welcome, Mr. Bailey.
Good afternoon, Representative Sylvester. We don't have Senator Rafferty with us right now, do we?
We do indeed. He is in the middle of my square, right around where Marsha Brady.
Oh, there he is. Okay. Hello, Senator Rafferty. Thanks very much. And members of the Labor and Housing Committee. Thanks for having me again this afternoon. I will start just by saying that as I've listened to the testimony and some of the questions, we weren't sure in terms of this bill or whether it was the intent was for public or private. Obviously, in terms of representing the Maine School Boards Association, the Maine School Superintendents, we're anticipating that this would have impact on public spaces as well. I am here today on behalf of the legislative committees of the Maine School Boards Association and the Maine School Superintendents Association in opposition to LD 358. As you know, school leaders do take their responsibility to keep children and staff safe very seriously. That certainly has been demonstrated in this extraordinary year of COVID-19, where because of our precautions, schools have remained one of the safest places to be for both children and adults. This bill requires the Board of Occupational Safety and Health to establish minimum and maximum temperatures in public school buildings. Those rules would affect roughly 400 buildings across the state. We're first to acknowledge that we have old school buildings in Maine. The list is long for districts hoping to get funded for major school construction projects, and it will be many years before aging buildings are replaced. I've attached a copy of the list to my testimony. It also can be viewed at the link that's noted within my testimony. Currently, school personnel monitor indoor temperatures and attempt to mitigate them on hot days by opening windows. There are times when buildings become too hot and schools must be closed for the day. There are also buildings that get cold, and the choice is usually to put on extra sweaters or jackets. I would also add that schools have in place temperature monitoring that they do on outdoor recess. So they're always taking a look at temperature to be identifying, what's the safe and best practice for students as well as staff who would be out there supervising. These are imperfect mitigations, but they are practical and acknowledge that we don't have unlimited construction funds nor construction capacity to address the problem as quickly as many would like. We welcome your suggestion, short of closing schools, a proposal we don't believe the public would support. And with that, I would welcome any questions you might have for us. Thanks for having me here today.
Thank you, Mr. Bailey. Are there any questions for Mr. Bailey? So, Mr. Bailey, I know that, for example, out on Peaks Island, currently we're in a building they created in the 1800s and remodeled in 1910. And so, currently the windows are open, but people are prepared for that, right? They know that this is the situation that they're coming into. It sounds like certainly this school systems would have a lot of experience in terms of trying to regulate temperature. So if a board was put together of interested parties, I would assume you would want to take part in that.
That would be correct, and we didn't enjoy the opportunity to do that. Thank you.
Appreciate you. Okay, thank you.
Thank you.
I believe Curtis Picard is next, followed by Eric Venturini, followed by Greg Dougal. Welcome, Mr. Picard.
There we go. Good afternoon, Senator Rafferty, Representative Sylvester, and members of the Labor and Housing Committee. I'm
Mr.
Curtis
Picard,
Picard. and I'm
before you go
president-
forward, have you
Sure.
testified in front of us before?
I have not. I was supposed to last week, but another committee got in the way.
We've been giving folks who come up before us sort of regularly an opportunity to introduce themselves. So go ahead and testify, and then I'll give you that opportunity when we finish our 3 minutes here.
Sure, I appreciate that. Thank you, Representative Sylvester. I am Curtis Picard with the Retail Association of Maine. We do have members statewide, and I'm here today to testify in opposition to LD 358. We're not aware of any state that has a regulation like this on the books, and as you've heard from other folks, even at the federal level, OSHA has not addressed this issue either. You know, you've heard a lot of testimony already, so I don't want to read the written testimony that I submitted this morning. I do want to point out, as has been noted by other folks, the workspaces for retail employers can really vary. So for a grocery retailer, as was mentioned, warehousing, food preparation, refrigerated areas, but even the entryways where grocery carts are stored are going to have a different temperature climate than the interior of a store. Or a retailer that sells farm equipment or makes candy is going to have different temperature requirements. So it was interesting to hear part of the conversation this morning. And I'm going to be upfront and honest with you. You know, I think if you do want to put together some sort of study committee, maybe it's best to limit it to public sector buildings, because the challenges that the private sector would face would be similar that the public sector would face. And I think we all know that there are certain committee rooms within the Cross Building and the State House that are warmer than others. I'm thinking specifically the Taxation Committee, the Environment and Natural Resources Committee, and then on the 4th floor of the State House as well. Those can often be challenging when the weather gets hot as well. So perhaps it would be beneficial for the state to look at public buildings first to see what's really involved with pursuing something like this before looking at the private sector. Our retailers are doing the best they can to try to get through the pandemic as best they can. And it's certainly a challenge, has been a challenge, and we just want to get people back on their feet as quickly as possible. So I'll stop there, and I'm happy to answer any questions you may have.
Thank you, Mr. Picard. Are there any questions for Mr. Picard? I'd noticed, Mr. Picard, that you were talking about regulations. It sounds like we're maybe talking about guidelines, but if there was such a group put together, would you be interested in taking part in that?
To be honest with you, I mean, of course we would try to, but as I said, we're trying to help our industry recover through the pandemic. And when I think about the best use of my time, we had a meeting this morning with DECD talking about the next few months, what summer tourism is going to look like. That's really where I want to focus my time this coming year, is getting our economy back up and running the way it should.
Very good. Thank you I appreciate that on all your work. All right. Thank you, Mr. Picard. I believe next we have Eric Venturini. Welcome, Mr. Venturini.
Good afternoon. Good afternoon. Thank you, Senator Rafferty, Representative Sylvester, and esteemed members of the Committee on Labor and Housing. My name is Eric Venturini, and I'm the Executive Director of the Wild Blueberry Commission of Maine, the voice of Maine's wild blueberry farms and businesses. Wild Blueberry Commission of Maine is a quasi-governmental organization funded by the wild blueberry industry in the state, and we represent the voice of Maine's wild blueberry farmers and business people. We produce about 10% of all blueberries grown in the US, and near 100% of wild blueberries grown in the US. Due to economic factors, Maine is currently losing wild blueberry acreage and farms. We've lost about 20% of Maine's wild blueberry acreage in a 10-year period, going from 50,000 acres in 2007 to 38,000 acres in 2017. This year, 2020, I think everyone would agree, has not been a good one. In addition to the challenges of COVID-19, we have faced climate change-induced drought, a series of late frosts. At the end of the day, we saw about a 50% reduction in yield compared to what we were expecting. My point is, of all the years to legislate additional burdens on businesses, this would not be the one. My second point, it's one that's been raised by a few people already. The Occupational Safety and Health Administration already considered rules on indoor air quality and would have dealt primarily with office temperature and humidity. In 2001, they determined that temperature and humidity are matters of human comfort, not a safety issue, and terminated the proceedings. Third, if this committee passes this bill, I ask that you consider the unique nature of agriculture. As written, this bill applies to indoor places of employment. Does that include greenhouses and high tunnels, which are built to capture heat, frequently are above 90 degrees in the summer? What about processing plants that in the wild blueberry industry are where berries come from the field, are cleaned of sticks, leaves, debris, washed and frozen? As a matter of food quality, these processing plants are cold. In the wild blueberry industry, it's of the utmost importance to remove the field heat from berries as quickly as possible. Later, as they go down the line, they're frozen and moved into large commercial freezer spaces, kept at very low temperatures. This means the processing plants are kept intentionally cold, all to create a high quality, healthy, and delicious product. Fourth, what scale of business does this apply to? Would this require that a small family wild blueberry farm with a roadside market and one employee on the cusp of closing their doors due to the challenges of 2020 install an air conditioning system? If so, who bears the burden of that cost? And finally, this bill comes at a time when the Honorable Governor Mills, state agencies, and the Biden administration are all looking to combat climate change. Neither heating nor cooling are climate neutral. Mandating or even providing guidance could increase carbon and greenhouse gas emissions and increase the burden on ag businesses across the state that are reeling from climate change-induced drought and COVID-19. On behalf of the wild blueberry farms and businesses in the state of Maine, I ask that you vote ought not to pass on this bill. Thank you, Senator Rafferty, Representative Sylvester, and the Committee on Labor and Housing for your time and consideration.
Thank you, Mr. Venturini. I believe Representative Bradstreet, who is a fan of blueberries as much as Amato's Italians, has a question for you.
Thank you, Mr. Chair, and I am a big fan of wild blueberries. You bring up an interesting point, because I have gone on the wild blueberry tour. I've gone on the Maine potato tour before, and your testimony, I think, underlines a question I'm asking is that when we talk about temperature in certain situations, we're not talking about just what might be acceptable or comfortable, or even, I guess, under the guidelines of so-called safety for the worker, but is it the product as well? For instance, I know in the potato industry, it's very delicate. You have to have the temperature and humidity at a certain level in order to preserve the product. Is it true also with the blueberry industry?
That is absolutely the case. In the processing facilities themselves, they're kept at certain temperatures to improve the quality of the product. Even the smallest scale businesses, they're running, they're cooling the berries off as quickly as they can, getting what's called the field heat out of the berries. That's even when they're sold in what's called the fresh pack market, fresh wild blueberries as opposed to frozen. So temperature is a critical piece of producing a quality product. Yes, thank you for your question.
Thank you.
Are there any other questions for Mr. Venturini? Seeing none, thank you, sir. We appreciate your testimony today.
Thank you.
And I believe next is Greg Dougal. I believe Mike Rowland is after that, but I will check on that. Representative, or Mr. Dougal, I just elected you. Congratulations.
I don't have the stomach for what you do, Representative Sylvester. I'll leave that to you.
Yeah, it was a very loose congratulations, sir.
Thank you, sir. Senator Rafferty, Representative Sylvester, and distinguished members of the Labor Housing Committee. My name is Greg Dougal, and I'm here today to represent Hospitality Maine and our over 1,000 restaurant and lodging members to speak in opposition to LD 358. Obviously, we all want a safe working environment for our employees, but this bill would put us in uncharted waters, as you've heard. A one-size-fits-all approach to temperature control could put many industries, most notably the restaurant industry, which I represent, at risk. We've just suffered through the worst year our industry has experienced in modern times. We certainly do not need additional costly laws or regulations to hamper our recovery. OSHA does not even define, as Mr. steal some of Bruce Garrity's thunder because he stole mine. OSHA does not even define minimum and maximum temperatures in the indoor workplace at the federal level. They have recommended temperatures for office spaces, but not specialty workplaces, as we've heard. We believe that this is true based on what would seem to be the diversity of these workplaces that exist. They may be warmer or cooler based on the type of operation conducted or the end product that is being produced, not to mention the seasonal aspects to temperature variances. Again, OSHA has suggested guidelines for office environments, but no mandated temps in any spaces, including offices, as is proposed here. Directly from their website, OSHA does not have specific regulations for indoor workplace temperatures. If OSHA, with the might of the federal government behind it, is unwilling or unable to make these recommendations with all the resources available to them, what ability will the state of Maine have to conduct these same analyses that could potentially cost employers sizable sums of money to adhere to? 25 states have outdoor workplace temperature standards, but as far as we can tell, no other state has undergone this type of review and oversight for indoor temperatures, and none that we can find have this type of statute. California has discussed it, but nothing has been acted upon to our knowledge. This legislation could have a sizable impact on many different types of businesses, from science and technology companies, precision machine shops, storage and warehouses, and kitchens, of course, our main concern, and thousands of licensed establishments, both takeout and dine-in. There are kitchens in hospitals, schools, nursing homes, food pantries, churches, and as previously noted, it could be difficult and potentially very expensive to comply with these rules. So we do encourage you to please vote LD 358 out, ought not to pass, and I beat the buzzer. I can't hear you, Representative. You're on mute.
Oh, I was riffing about legislative time, but we'll just skip that. All right. So appreciate you being under. Are there any questions for Mr. Dugal? Seeing none. Thank you, sir.
I'd love to be on that. If there is a study committee, I'd love to participate if I could.
I'm sorry. Yes, I forgot to ask you. Thank you very much. Of course, we'll put you on that. We'll send it out to the interested party list if that's something that the department decides to go forward with, or if this legislation is successful. Thank you.
Thank you, sir.
Melissa, is there anyone else to testify opposed?
Nobody registered. We do have a few for neither.
Okay. Who is our next person for neither for nor against?
Next would be Donald Flannery.
And who follows that?
Michael Rowland, then Peter Gore.
Thank you very much.
Mm-hmm.
Welcome, Mr. Flannery.
Afternoon. Senator Rafferty, Representative Sylvester. I'm Don Flannery, the Executive Director of the Maine Potato Board. And we represent the potato industry, like we say, from Fort Kent to Freiburg and Bethel to Belfast. Excuse me. When we saw this bill, a lot of the questions we had and concerns you've heard already today. And the reason we come in is neither for nor against is sometimes you read these bills and you think there's a good reason for them, but you have some concerns how they may impact you. And that was our concern. And as it relates to our industry, it's a very unique industry compared to others. You heard a little bit about wild blueberries, but potatoes are somewhat the same way on the processing side, but also on the storage side. When you harvest a crop in September in October and you keep it till the next June or July, you can imagine that you've got to have some really unique conditions in which you store those potatoes. And those not necessarily aren't comfortable conditions as some may consider it. So when we looked at it, we had all those concerns. We learned a long while ago that the devil's in the detail, and the detail's in the rule. And this just says that the department will develop a rule. So our concern is that if this legislation goes forward, the special circumstances you may say as it relates to agriculture or any other business you've heard today, those are considered in developing of these rules or programs or guidance, however it comes out. So that was our concern, and that was the reason we went neither for nor against, thinking there's maybe some very valid reasons that this is important, but we didn't want to be left out of the discussion. And we didn't want to have our concerns as it relates to our industry not considered. So I thank you for your time and gladly answer any questions.
Appreciate that, Mr. Flannery. And if we have a couple bills here that we might see you, we usually see you over in ag. But if you wanted to take a minute, just tell us about the potato industry and your members.
Sure. The Maine Potato Board is an industry organization. As I said earlier, we represent growers, dealers, and processors across the state. We are a self-funded organization in that the growers and the processors pay an assessment on every 100 weighted potatoes that's sold that funds our organization. Their funding comes through grant opportunities that we may pursue. And also, until last year, if anybody had been to Springfield, Mass, the Big E, which didn't happen last year, and I'll have doubts if it happens this year, but so that's a little bit of our organization. We do a lot of work in Augusta, representing, advocating for our growers. We also have on staff a plant pathologist, an engineer, and an agronomist. And our focus is a little different than other commodity organizations in that while we represent our industry, we don't do a lot on marketing and promotion. We've made a decision about 15 years ago that we need to be putting our resources to best benefit the industry, and that's for the things that the industry can't do for themselves. And that's why we have an agronomist, plant pathologist, and an engineer on staff. And so that's, we usually have a tour every 2 years. This would be the year for our tour, but it doesn't look like that's going to happen probably either. So if anyone that is in the legislature in the 131st, hopefully we'll be back on tour schedule, and we welcome anybody that would like to come up and do a tour to do so.
Thank you, Mr. Flannery. Are there any questions for Mr. Flannery from the committee? Seeing none, thank you for being here, sir. It's always good to see you. We love the co-op and appreciate all your work on behalf of Maine.
Thank you.
Alyssa, is Mr. Rowland, is Director Rowland next, I believe?
Yeah, he just came in.
Okay.
Followed by Peter Gore.
I'm getting quicker at this. Keep me practicing. Am I here?
You are all set, Director Rowland. We can hear you and see you.
Thank you. Greetings, Senator Rafferty and Representative Sylvester and the members of the Joint Standing Committee on Labor and Housing. I'm Mike Rowland, the Director of the Bureau of Labor Standards at the Maine Department of Labor. I'm here today to speak on behalf of the department, neither for nor against LD 358, an act to protect workers from unsafe working conditions with regard to indoor temperatures. If passed, the Board of Occupational Safety and Health would be asked to write rules laying out the minimum and maximum temperatures for indoor places of employment. We want to offer this testimony in order to provide additional information that may be helpful. You've probably heard some of this already, and I want you to remember that I'm testifying on the bill as written, without the conversations that have preceded it. The Board of Occupational Safety and Health oversees the regulation of safety and health issues in the public sector, state and local employers only, since we operate as a state planned state. Federal OSHA maintains enforcement of private sector employers and the federal government. The department's Workplace Safety and Health Division receives occasional inquiries and offers consultation services to all, but we do not have enforcement authority in the private sector. It's also important to note that neither OSHA nor Bosch, the Board of Occupational Safety and Health, currently has a standard for temperatures at a place of indoor employment. Any such workplace standards would be determined either by employer policy or by collective bargaining agreement. And in fact, this isn't my written testimony, but I can forward it to you. The Department of Administration and Financial Services in the state already has a policy on the maintenance of temperatures in state employee occupied facilities, which, as I said, I can provide to you. And that would be the area over which we have authority in addition to local government employment. So thanks for your time and attention. I'd be happy to answer questions.
Thank you, Director Rowland. Are there any questions for Director Rowland? Seeing none, thank you, sir. Alyssa, is that our we have Peter Gore next, and then that's our last person to testify?
That's correct, yes.
All right.
Good afternoon. I am hoping, oh, there we
Mr. Gore, we can't, there you go.
There we are.
You might want to turn up your volume a little bit. I at least am having a little trouble hearing your voice.
Hang on, can you hear me now? Is it any
We
better?
can hear you, but it's difficult. And you're a projector, I know.
Can you hear me now?
Perfect.
All right. No earplugs then. We'll go earplug free. And it's an unusual place for me to find myself last, and a dangerous one before lunch. So I'll try and make this direct and to the point. Representative Sylvester, Senator Rafferty, members of the Joint Standing Committee on Labor and Housing. I am Peter Gore with the Maine State Chamber of Commerce. The reason we didn't oppose this bill outright today is because we recognize that the board really doesn't have the authority to do what the bill envisions. That's the purview of OSHA, as has been discussed this morning. And OSHA recognized that there's a difference between being uncomfortable at work. I think that's something we've all been at some time or another, and being unsafe at work. And as a consequence, providing or promulgating the kind of standards that this bill envisions at a state level, they've decided not to do it. And they cover this through the general duty clause in OSHA, which requires employers to make their workplace safe for their employees. It's hard to imagine what a one-size-fits-all would look like for the state of Maine when it comes to minimum, maximum indoor temperatures, because our economy is so varied. And to be honest with you, it will change. I mean, that old adage, wait a minute and the weather's going to change in Maine, or you get 4 seasons in one day, is very true. So that someone's workplace conditions could change by the minute, by the hour, by the day. And so trying to come up with a standard that would work, at least around safety, and be affordable for employers, I think would be an impossible task. So those are my comments for you this afternoon. I appreciate it, and I'll try and answer any questions that you have.
Thank you, Mr. Gore. Are there any questions for Mr. Gore?
Representative Sylvester, can I add one more thing?
You sure can. You have time left.
So I've been around long enough to know and remember the days when the cross office building was not air conditioned. And my time in state government was at 221 State Street, across the street from the state capitol of the old DHHS central office buildings, which was also not air conditioned. And there are standards, I believe, as Mr. McCabe indicated, around public safety. And those are challenging enough as it is in the public sector, excuse me. And enforcing those standards back in those days when on a very hot summer stretch with very high humidity, employees would be sent home. On the 6th floor of the Cross building, the temperature could be well above 100 degrees. And the CBA called for employees to go home under certain conditions. But those are difficult standards over time. And I remember, the arguments that would go back and forth around, are employees going to go home or are they not? And then you try and translate that into the private employer sector, excuse me. I think it'd be very, very challenging.
Thank you, sir, for that additional comment. And that concluded right on your time. So, yes, you have that clock inherent, apparently. Are there any other questions for Mr. Gore? Seeing none, thank you, sir.
Thank you.
Is that it, Alyssa?
That is it.
All right. Well, seeing no other people to testify, that concludes the public hearing on LD 358. And I am going to turn the gavel back over to Senator Rafferty. We have 2 work sessions today. I believe we'll probably end up taking a caucus/break. And we thank Representative White for being here as well on that last bill. And so I will turn it over to Senator Rafferty.
Thanks very much, Representative Sylvester, and a great job. You moved us right along there. So you may be doing this more often. Appreciate it. I'm looking at about, what do we got? Like 1:05. What if we take a break and reconvene at 1:30? And I have us looking at, in our work session, in case you forget, we're looking at LDs 61 and 111.
Senator Rafferty, would you like, as we'll have to leave the public hearing Zoom and go to the work session Zoom, would you like everybody to go in there first and then leave? Or would you, in case they have problems, or what time would you like us to come back? How would you like us to do that?
Why don't we get us all in it first and then we'll leave? Okay.
That sounds great. Thank you.
Okay.
Thank you.
I'm going to send you all the email in just a second.
Thank you, Alyssa.
I do have to end this and kick us all out before I can start the next one, though.
So we'll leave.
I will